Yes.
Adjournment request, if any, from item number 1 to 4. From item number 5 to 13, adjournment request.
I beg to mention item 5 and 6 of today's daily list.
5 and 6 also?
Yes.
Acha, 5 and 6 are together.
Okay.
All right, adjournment slip.
That's all like-
Your date?
January.
Lordship, I beg to
20th
mention
January.
item number 9 and 10.
8, 9 and 10.
9 and 10.
8 is different, 9 and 10, all right.
My lord,
May we get a fixed date? My lord, it's a date reference matter.
21st of November, madam.
Death reference matters. I have kept it in my roster. The day you want to argue, we will hear you.
My lord.
So let it be on 21. then, madam, for
21,
convenience
11,
for-
my lord, if it's
Acha, appellant has not sought time, the public prosecutor. Who?
He is the
Master,
public.
why do you take time in death reference?
my lord, what has happened, my lord, this matter was earlier taken up or was taken by one of our senior colleague,
Madam-
my lord, who has been elevated, my lord. So yesterday only I,
That may not be a big ground, but you get ready and we will hear you sometimes in second week of November, not beyond that.
my lord. My,
Second
Right.
week of November, I'm here. Yes.
my lord.
Second week of November, I would like to hear that.
Yes, deeply obliged.
Like, second week of November.
Well,
Lordship, with the consent of the other
Adjourn-
side, I beg to
adjournment.
mention item number 40.
Adjournment request by public prosecutor.
11 November.
Yes,
May I
any
please-
other matter?
Lordship, item number 14. The matter may be
No, no,
listed
first,
after.
eight,
Eight,
nobody.
item 8.
Lordship, with the consent of other party, I beg to mention item number 8.
8.
Mr. Kane, yes, all right. All right, when you want it,
Lordship, in the last part of November,
that we can't, December or January. All right, yes, next.
2nd December.
Lordship, I beg to mention item number 14, Lordship. The matter may be listed after a week.
January. Adjournment slip, January.
Lordship, I beg to mention item 20. Lordship, here I
Okay,
was required to file an affidavit. I'm filing it within the course of the day, Lordship. Can it be on any other day, Lordship?
Mr. Phuken is online.
Yes, my lord, I appear for the petitioner, my lord.
So today he is filing the affidavit.
Yes,
He'll
my
have
lord.
your local council will receive the affidavit today. We'll
My-
have it on some other day,
Sir, may I request for 25th of November, if convenient, my lord?
25th of November.
That's right.
They don't ask great on behalf of
Lordship,
the respondent.
25th
Let
of
us-
November, Lordship, there is some difficulty, Lordship. The Advocate General is appearing,
27th of November,
Lordship,
27th of November.
much obliged.
No difficulty, my lord.
All right.
Obliged.
May it please, Lordship. Lordship, I beg to mention item number 21
Yes. On behalf of,
on behalf of Dr. Ashok Shah,
on behalf of the petition, no appellant.
petitioner appellant.
All right. As prayed for.
Obliged.
लिख देना adjournment slip सब लिख
February. February.
Hmm?
In month of February.
February, January. February, everything.
6 January. Any other request? Daily list for orders item 1.
Lord, the
Yes,
matter relates to promotion
Yes.
and my Lord, I think all these steps are complete. So Lordship can fix the matter for hearing, for admission hearing.
All respondents are
Yes,
served.
now it appears, pleadings are everything are over. My Lord,
When do you want it? The issue
Is it-
is only merit come seniority, seniority
no,
come
my
merit.
Lord, no.
Then
Here is a criteria, it is merit and suitability with due regard to seniority.
no, that's right.
Huh.
That's right. So
Huh.
therefore,
Huh.
both are
No, no, no,
almost
no.
similar.
No, my lord, no, with all respect, my lord. Merit and suitability with due regard to seniority. Seniority plays a role even at the time of assessing assessment of merit. Here in the case, my lord, I am at serial number 4. They have changed the rule 4 times.
Okay,
Once qualifying service was 2 years,
All
it was
right.
made.
we'll hear you.
Huh.
We'll hear you.
Milord, I was praying for 11th of November, Milord, because this is
Yes,
only
November.
11th, only 11 months of service is left. He's the senior most, Milord.
Manoj, I have to come from Delhi. Can I request for 2nd or 3rd of December, Manoj? November may not be possible.
You have to take consent of Mr. Chaudhary.
Plus, November, I'm a little tied up. Manoj.
December.
Second
No,
or third
first
of
week
December.
of December, we shall, yes,
Okay, Milord.
just a
Second,
minute,
fourth,
first
Milord.
week of December,
No,
it
no.
shall be before any other time.
2nd December
Second
is
or
a
third.
Tuesday.
Whatever, second or third.
2nd is a Tuesday, Milord.
All right,
Second, please. I'll be highly obliged.
here the service is complete. Let this matter come up for consideration, with the appropriate heading on 2nd of December.
Pilot.
Item number 2,
Yes.
My lord, here, my lord,
Yes,
my lord, we find it little difficult to reconcile, but the two judgment, my lord, first by the coordinate bench, my lord. Lordship will kindly have a look. Here, the petitioner's case is that the distance we have given in the NIT was 90 kilometer. We cannot reduce it to 76 after that.
yes.
So in this case, Lordship, the distance in the NIT was 232 kilometer. It was increased later. Then he therefore claimed the balanced amount. This honorable court has held that since we have found that it is increased, you must give him. So there are two inconsistent. They can't be. That's why Lordship will kindly have a look at that. He cannot get both ways, my lord. That's why. Same petitioner, only, my lord, the route was different. And we have paid the.
They pay for food, then they have to. Same rule would not apply. If it is, if let's say. Who made that in plan? I think, the argument of. Negotiate with. Acceptable, but we have made a distinction. It's made a distinction. He'll deal with it just now. Now, please read that clause B2,
My lord,
clause B2
of the my lord, contract.
of the tender. Of the tender paper.
D2, my lord. Clause.
B2, B
B2,
for
yes.
Bombay.
Yes, lordship. B2.
That perhaps has been quoted
Yes,
in
lordship.
internal page 18 of the
It
judgment.
says there'll be
Read it first.
B2.
What it says is your interpretation. Let us read it in
Lordship.
its entirety, what it says.
B2 টা বিজন করতে স্যার Yes, B2, my lord, may I read it? Tenderer must get themselves fully acquainted with the size and location of godowns vis-a-vis loading, unloading points before submission of the tender. The rates quoted by the tenderers shall be deemed to have been done after such acquaintance. No tenderer will be entitled to any compensation arising out of any misapprehension in this regard. Before tendering, the tenderer must also get acquainted with the conditions of route to be taken by him for transportation of food grains, sugar, etc. Once the tender is submitted, the tenderer will be deemed to have fully acquainted himself with the route, and he will not be entitled to any compensation on account of blockade, diversion.
etc. on the route. Now, therefore, if over a period of time, while the contract is in force, a person takes a longer route, says that he had to cover a longer route for coming from one loading station to another unloading station, that is not permissible.
That's-
He had to get himself acquainted. So there can be no increase. Now, this is not conversely true. Suppose there is a tentative distance given which has been accepted by the tenderer, say 90 kilometers, the distance. And bills have been raised on the basis of per metric ton per kilometer. The assessment was of the NIT, assessment was of the FCI. Right? Now, later after about 5 years, you do an audit. By what mode? How have you discussed it? You reduce it to 74. Now, for that, let us now come to clause 18A. Forget about do conflicting judgments. These are all single judges' judgments. We are of a bigger strength because of the number. So let us see the merit.
18A, right? It
Right.
says all rates are firm and the period of contract, no escalation whatsoever shall be entertained.
No
The rate-
escalation whatsoever shall be claimed or considered except as provided. Now, what
Never.
has been provided? Just see this.
The rates of transportation for goods are on the basis of net weight. My lord, that
Yes.
is my case. In fact, my lord,
Just read it first, then you'll explain.
yes,
Hmm.
the rates of transportation of food grains are on the basis of the net weight of food grains.
That's right.
Right.
It is per metric ton per kilometer.
Per kilometer. Therefore,
Hmm.
therefore,
This is not in dispute here. You can't argue on this. Read next. are on a
no
different
separate
issue altogether.
remuneration would be payable for distance covered by loaded lorries or return so
Or
on
the
garage
return.
from so and so. Then for the purpose of calculation of transportation charge, the distance shall be in all cases be rounded off. The distance will be reckoned as fixed by the chief engineer and nominated by so and only by the general manager, verified and acting. So we have verified the distance. We found it to be 76 kilometers.
Now, how? The tentative distance you had given 90.
No, Malad, that was only tentative. That was
Just read. No compensation shall be admissible to the contract.
admissible to the contractors or in respect of detention of trucks, godowns and other loading, unloading or points. Unless the detention of an extraordinary kind, that is a different matter altogether, my lord. So, my lord, any extra distance, we are not.
Now, under which provision did you have it recalibrated, recounted the kilometers? Under which provision of the tender paper? Under which provision of the tender paper? In fact, you had suggested that it is 90 kilometers. If you're not satisfied by this assessment, go and see the site for yourself.
Yes, so he has calculated it.
He says that whatever you say, I accept it. 90
No,
kilometers. I don't want any escalation.
What I understand from this clause, my lord, 18 B2, it is that that the contract, we have given 90.
Hmm.
But it is contractor's duty to ascertain it. If he finds it to be less, he could have said, told us, my lord, that it is less. So I'll quote it in a different way. He did not say. So you cannot,
No, but who did that? District
my lord,
committee
the fact-
verified, assistant general manager, communication
my lord,
issue.
it happened like that. Before each contract, they made this assessment. After that, he found when it is only 76. That was paid all by mistake. That was a mistake done. And if it is per kilometer per metric ton, then the distance between 76 to 90, there is no question of per kilometer per metric ton. my lord. Payment is per kilometer per metric ton. So if 76 to 90, there would be no per kilometer per metric ton.
I don't follow what you're talking.
My
I
lord,
really don't follow what you're talking.
what I'm saying, my lord, that it
Now,
must
where
be.
is that dispute coming into picture per metric ton per kilometer? It's only the question of, nobody has questioned the weight of the food grains which were carried by the tenderer.
No, by that, what I mean, my lord, is that you will be paid for the distance you transport.
That's right.
Right. So if the distance is, it is not disputed, the distance is not 76. He has not also disputed.
No, no, who says, I mean, how do you read all this? It is not disputed. That is the dispute which is at the core of the dispute.
No, my lord, before
no?
my lord will kindly have a look at that.
I don't think you're on the issue which is required to be decided here.
No, my
The
lord,
question is only this.
That's
Look at this. There is no
Yes.
difference. There is no dispute with respect to what you are saying that there is, it is undisputed. No, it has been disputed by the tenderer. By the respondent, it has been disputed. Now,
Right.
he fills in the tender. You select him. He accepts it without a demur that it is 90 kilometers. Well, even if it is more, I don't bother. I would charge only for 90 kilometers. Correct? And
I just add, my lord, when he quoted the rate, he did not say it is 90
please hear
kilometer.
the other side. Please hear the story of the other side, Mr. Food Corporation.
Lordship.
Now, that's
lordship.
true. You are at a loss of about 2.5 crores.
That's right.
But that's your fault. And this you do after 5.5 years, after the discharge of the contract.
No,
After 20 years, you will find that you had made overpayments.
no,
I mean, there has to be a limit, no?
my lord, your lordship.
Mr. Roy, try and understand this. Don't bring in this concept of per metric ton per kilometer.
All right.
That is not in dispute. I don't know where have you brought this from.
No,
That's not in dispute. The dispute is only with respect to the decision of the FCI to demand 2.5 crores as having been overpaid to the tenderer. Now, why it is so? He has not claimed any excess kilometer travel. Not at all. Whatever you said, that was accepted. Now, please don't think that when the pitch of the voice is raised.
No. I can never.
That's the way I would like to argue with you. Correct.
My lord, we also by mistake.
No. Therefore, I make it very clear to the advocates. Many a times, I have a higher
No,
pitch.
there is no
Don't take it
question.
otherwise. But then the purpose is only to, put across the point which I am trying you to understand,
Exactly.
or for you to explain it to us.
That's right. lord.
Now, this is 90 kilometers. It is none of the tenderer's assessment. It is your assessment. You accepted it. Now, the clause says that whatever is the distance, we tell you, if you're not satisfied, you go to the site, select it, and then file your tender. So he says that, well, your assessment is correct, 90. I agree on that. And he agreed, he delivered, he raised a bill, you made a payment. Now, after 5.5 years, I mean, there was some brainwave to your audits, to some body which is not a statutory body, some district committee of the corporation. And by what method did they measure the land, measure the kilometer? And they say that no, it is not 90, it is 74. Which mode? Why? How? And under which provision of the tender paper? That's the issue.
There is none. bro. There is none. bro.
That is the issue. Why were you making it unnecessarily
No, that's
complicated?
what I submit, my lord. Just one point I to my lordship. If lordship kindly come to page 59. by this, my lord, this is not after so many years. In
5.5 years.
no, 2017, he made some deduction and he accepted that. 2017,
That's where he committed a mistake.
right.
And you are a very strong party.
That-
And anything has to be dealt with by keeping the principle of contra pro frentem. A weaker party has a right. to
No,
be
no,
cons-
that's-
I mean,
Because we
He accepted-
formulate the terms, we
He's,
formulate the
he's a
terms.
tenderer for you for different locations, for different godowns. You start, deducting the bills from the other account. Can you do that?
No,
Can
that
you do that?
we have a set of clause, my lord. That's for sure, of course, that's a different matter. We have a,
See, we understand 2.5 crores of the government going
oh,
to a
that's,
private
that,
contractor.
that's
It's a very
what-
serious matter.
that,
And
exactly.
therefore, we would not be very off the line when we say that you ought to be prosecuted.
My lord, lordship.
Your officers ought to be prosecuted.
Exactly, my lord.
And you have been very casual in
Making fact.
deciding about this kilometer business. And therefore, your officers should be put in the dock and they should be tried for why they made a wrong assessment. Were they in collusion with the tenderers?
And my lord, if the audit would not have come, that would have gone, my lord, that way. That because of the audit, we found it. And that's right, because of the audit. Your lordship is right, my lord. That has to be some.
Now you can argue whatever point you wanted us to understand.
But the first point, as I said, my lord, in the same petitioner, same contractor, he claims when the distance
Is that in dispute today?
it is not, but he has raised this plea before us. And says, why do you do, he has
What did
raised,
he say? What did he say?
your lordship kindly have a look at page 761.
Of the judgment,
No, my lord, the appeal, your lordship, page 61,
page 61.
the lordship. And also others. Page 6, I'm sorry, page 60, my lord, page 60. And 61 also.
Yes.
It's a down below page, my lord, serial number 6. Para 6, that it is herein particular to mention several locations for other transportation routes. There has been a subsequent increase in the distance covered by the said route as against the stated NIT of the MTF at that submitting tender. These cases have however not been considered for recalculation.
No, this is the request which is beyond the terms. They were not entitled to be paid for this.
That's
So
why
this was-
when he is referring
No,
to,
Mr. Roy, I think.
because it is only after that he filed the subsequent case.
Mr. Roy, you're conflating two different issues altogether. This is a request made by the same tenderer with respect to another site. Correct? It was for you to decide. Now, what did you decide? Why are you?
We have decided, we have not given on that.
You're not given.
No.
Right.
And this
So
court
what
said
you-
give him.
Huh?
This court said give him.
No, that you challenge that. You challenge that.
We have
You're-
challenged that.
That is beyond the terms of contract.
Yes, sir.
Nothing could have been paid as by way of escalation. Nothing. Now, this judgment by another bench, that's not under challenge. You're not challenged.
No, I have challenged it before this division bench. Division upheld this, went to the Supreme Court. Supreme Court said nothing doing, therefore we made payment.
I don't know. I really don't know.
We made
You could
payment.
have, what was the ground? You could have said that it is beyond the terms of contract. We cannot. He has to accept the liability. You lost it from Supreme Court. So why do we have to talk about that? So
No.
are you trying to tell us that because he got more for something where he had settled for less, therefore here he has got
Exactly.
more, we will reduce that amount? Is it a tit for
Well,
tat
that
Is
I
it-
leave it to your lordship.
kind of a situation? Is it?
My submission was he cannot get benefits both ways.
You're taking us to the olden days. A tooth for a tooth, eye for eye. As if you have a talon to recover and claw back whatever has been taken from you by virtue of the Supreme Court, High Court Division Bench order, Supreme Court order.
No, my lord, that's not.
Here
there.
in this, we don't find anything.
My lord, I leave it to your lordship.
And what, and how did he say? Where is that judgment which you showed us? You showed us some judgment, two irreconcilable judgment
Oh, my lord, in WPC number
is the same.
214 of 2019. I've given a copy. My lord. Hmm? Hmm.
Open title. I don't think. Yeah. Just raise this plea, we will tell it. We will deal it. We can deal it. That's it. All issues are different. We don't know what was argued for. Now, this contract period was from 26, 2015 to 19/6, 2017, for 2 years.
2 years,
This
yes.
assessment, area manager had made that assessment in 2017, not after 5.5 years. Where did I get 5.5 years? The claim, the area manager thereafter confirmed it by letter date 2000. Other seen the subsequent date they were confusion. That the shortest route the test was without taking into consideration the voters. Yeah, I'm on a different, I'm on this. I'm on the inclusion.
It's all done after the contract.
Just a minute. Was extended for a period of a few days from 1960 to 27. That transport bills with effect from 29. लेकिन वो गलत है, अभी हम बता रहे हैं। After time. Okay. Mr. Roy, you did not point out. See, relevant facts, if you don't state, then perhaps the decision would vary. Now, the period of contract was, contractual matters have to be dealt with differently. The period of contract was for 2 years,
15 to 17.
from 26/2015 to 19/6/2017. That's exactly 2 years. It was further extended to 22/7/2017. That's for about 5 days. Extension was only for 5 days. And in that extended period
More than that.
1 month, 5 days, madam.
of 1 month, 5, no, yes, 1 month, 5 days.
1 month,
You're
5
right.
days.
1 month, 5 days. So during this period of contract, steps were taken to measure the shortest motorable distance from Changsari to Tangla. And the area manager found it to be 74 kilometers.
Yes.
Fresh assessments were made, and it was within that extended period that a report was made on 25/5/2017 that the distance motorable route was 76 kilometers. And therefore, what was recoverable was, to which he did not object, was the bills between
With effect from 29/4/2017.
29/4/2017.
That is the report of the committee.
From
First-
29/4/2017 to 22/7/2017. This was approximately 2 lakhs or 25,000 or something. What was that amount?
25 lakhs, madam.
25 lakhs.
25 lakhs. That has been recovered. Later, there was an audit.
Well,
An audit says
No,
that if this is motorable,
then vigilance audit. No?
and who decided whether the respondent was taken into confidence, whether he was shown, whether it was reconfirmed, whether it was the motorable distance, shortest distance, which could have been traversed. You said 90 kilometers, he agreed for 90 kilometers. The distance at times increases if a via route is created.
If the
Right is accrued in them. And then after deduction, you discharge the contract, and it was, the contract was
given
discharged.
the no
They have
demand,
no due certificate.
no demand means that is if any claim we have in respect to the contract. That is a different matter. The mistake is if the mistake doesn't come within 8 minutes. NDC not for the mistake.
Now we will go on the order pass, the reasoning given by the learned single judge is not perverse, therefore we will not disagree.
I leave it to you, Lordship.
We'll go on that.
I can't, my lord, make my.
You're right, Mr. Roy, but then you should have taken that decision that time only. When you made a deduction of 22 lakhs, you should have told him, you should have put him to notice. You can't continue it forever.
Lordship is right, my lord. We all by ourselves taken the decision. He was not taken into confidence. That's right, my lord, exactly. You know.
We cannot differ with this. For the reason, for very other reasons. You're right. He appears, he did not protest. That is the only thing which is holding us back in just dismissing your appeal. But then you said that, why should he say that was the time he accepted it? But there was no further inquiry that even during those periods, it was 74 kilometers and not 90 kilometers.
But it was all throughout 76 kilometers. That was the finding. Therefore, the High Headquarter said he must recover it from the date, from the beginning.
Now, suppose after 5 years, 6 years, you would make an assessment that the distance has become short, recover. There has to be a finality. Now we are seeing it. We are not only charging you. We are also seeing that there should not be any injustice.
That's why,
When it be
Lordship.
for 50, 60 lakhs,
After all, it's a public money. If he is due to him, my lord, he must get it. But if it is not due, my lord, the Lordship will definitely, it's a public money, my lord. And section 74 of the Contract Act says, if anything.
when did you raise the bill for 2.5 crores after 5.5 years?
No, my lord, the
What
Lordship.
is the demand?
My lord, section 3 of the Limitation Act says we are debarred from filing a suit or appeal. It doesn't make put any debarment on us.
We are not on that. We are not on the of issue of limitation.
Terms of the Lordship. The Lordship is a contract doesn't say anything, Lord. Terms of the contract doesn't say anything.
We may take a different view, but we refrain from taking a different view. We will go on that to justify ourselves. 4,822. And this whole thing, even the extended contract 70. No. Take it up. Let me dictate it here. What do you have to say? We have argued all case for you.
Yes, madam.
But you have not said
I have
anything
not- I didn't
in our
interfere.
support. He had a difficult time facing us. You did not say anything. What ground? Why should you be unnecessarily enriched by 2 crores? All case, all law apart. Why should you? They have not recovered interest from you. You have invested it in other groundings. And why did you accept it? Why did you accept to refund 25 lakhs? Therefore, there is practically no opposition from you.
My lord, I did not accept, my lord. Immediately, I filed two representation objecting this action. But ultimately, my lord,
No.
without
No,
giving us any
Be
notice.
sure on facts. You objected to the assessment.
No, your lordship, read the
Just a
whole,
minute.
whole
You
representation.
objected to the assessment. You did not object to the deduction. You objected to the assessment of the kilometer distance,
My lord, same
but you
thing.
never objected to the deduction. That was a mere representation saying that you can't do it. How have you come to this? That's all. There was no real effective resistance to withdrawal of 25 lakhs. 1. 2, with respect to another contract in a different rule, you escalated that amount.
No.
and you got it paid by the agency of the state under the orders of this court and the Supreme Court. So can you be allowed to blow hot and cold? Let us put a question to him. He is sitting tight, thinking that we are only thinking against Mr. Roy. Now you tell us why can't we look at this?
My lord, the legal service.
5.5 years is good enough.
Good, my lord.
But then for this fault, should you be made to sit richer by 2.5 crores?
My lord, it is on fact, my lord, it is not correct.
And if time has elapsed, then you have earned interest on that account also.
Lordship may kindly turn to page 107, 108, my lord. There was road diversion, my lord. When the tender was floated, roads were blocked. An inquiry was made by FCI that the conductor is saying there was road blockage, that's why the distance was larger. By the time it was completed, road diversions were not there. So they have measured it after I have completed the contract, my lord. The report, Lordship kindly find, there was a road diversion, my lord.
That's an argument. Where is that?
107, my lord. Well, 107 is a query made by the area manager to the executive engineer PWD. And 108 is the response.
2097.
This is no response. They say that there is no material. Then what happened?
My lord, that's why I say that, my lord, there was road blockade, my lord, confirmed by the executive engineer, my lord. But by the time I completed the contract, road blockades were not there. Roads were repaired, my lord. So they measured the shortest one, my lord. That's why otherwise, how come, my lord, they measured it 90 and it became 74, my lord?
This was 11/9, 2007. Where is the report dated 29/4/2017? Where is the report dated 29/4/2017, Mr. Roy? It's taken a lot of time for us.
2004.
Where is that report?
The report of the
29/4/2017 saying that distance is 76 kilometers.
no. It's I think it's not here, my lord. No, it's not here.
No,
Well,
that's how
Hmm.
the documents at page 107 and 108 could be understood. Now, page 107, the
Original-
area manager would make a request to the executive engineer,
Hmm.
PWD,
No. My lord,
for furnishing of a list of available routes.
the lordship.
Right. So then again, the information was by executive engineer that we cannot say there were diversions. But ultimately, how has he come to this conclusion? That we want to know. So therefore, it will be confirmed that during
From-
the period that he transported goods, there were diversions and therefore 90 kilometers. So this was post diversion. And post diversion, that also the report from 29/4/2017. That's a scientific way of taking that date.
My lord, then lordship, I can original record, but I can bring it tomorrow. I mean, on Monday, my lord, lordship will have a look. That's better, my lord, lordship. Look
My
at
lord,
it.
page 31 will reconfirm it, my lord. Page 31, Lordship, you can see, my lord.
Page
The main,
31.
page 31, my lord, annexure 5. That is why, my lord, the FCI authority said that this recovery will be only from the point it is detected.
No, that
Page
was,
31, my lord.
that was changed later by the FCI at quarter, my lord.
Last paragraph, my lord.
31.
31 here.
59, my lord, 31 will be.
Yeah.
59, my lord, 59. 31 is another page number is then.
এটা কত বললো? 29.
59. This is the main order, my lord, pursuant to which it was done. Last paragraph, lordship, kindly see. In the light of the above facts, competent authority hereby direct that the bills of the transport of the contractor may be passed on the basis of 76 kilometer with effect from so and so
Just a minute.
period.
Just,
Oh, 29.4 is the report only. Mm.
I. Let's take it to- 6, 7. This is much later, no? 26, 7. That is after the extension period. But this confirms that there were roadblocks. It may be the shortest notable distance, but it was not, the lorries were not to be taken on that distance. Mangal Dai and Way Bridge. Shortest motorable is. And you give your tentative assessment. Interest, it is funding. They were already deducted. No, but they have already deducted it. The money is there not to be paid. Get paid. Later. We have heard Sri P.K. Roy, senior advocate for the appellant FCI, and Mr. B. Chakravarti, learned advocate for the respondent number 1. The appellant / Food Corporation of India has questioned the judgment dated 23/1/2025, passed by a learned single judge of this court, holding that the contract between the appellant and the respondent was validly discharged on issuance of a no demand certificate and refund of the security deposit. Under such circumstances, the imposition of a refund by way of demand notice dated 4/8/2023 was known as void and therefore liable to be quashed. The learned single judge further directed for refund of the amount of rupees 2.11 crores, which was deducted from various other contract bills, contract dues of the respondent, which was payable by the appellant corporation within a period of 45 days, failing which interest at the rate of 9% would be charged from such amount. The learned single judge, however, declined to direct for any refund of 25 lakhs of rupees, which was not protested to by the respondent immediately after the discharge of the contract. Necessary facts for disposal of this appeal are as hereunder. Next, the Food Corporation of India had floated a notice inviting e-tender on 11/3/2015 for transportation of food grains and other articles from Changsari to Tangla via Weybridge. The distance that is for the distance of 90 kilometers. The respondent was one of the participant tenderers who was selected and appointed as the contractor on 26/2015. The contract subsisted for 2 years from 26/2015 to 19/6/2017, which was further extended up to 22/7/2017. After the completion of the contract, the respondent raised the bill on the basis of the terms of the contract and the distance which was assessed by the corporation between Changsari to Tangla. However, as it appears from the records, that during the extended period of contract with the respondent, an attempt was made to measure the shortest motorable distance between Changsari to Tangla via the Weybridge. And it was found that the distance was 74 kilometers. However, a confusion remained all through whether it was the shortest viable route a distance between 2 points, distance between 2 destinations. Those should remain invariable, but it depends on various other conditions, namely road blockade, diversions, construction, change of course, etc. When this assessment was made, the respondent was not taken into confidence, and he was absolutely unaware of the methodology of the appellant corporation measuring the shortest motorable distance from Changsari to Tangla. However, the report in that regard was submitted and accepted on 29/4/2017, holding the shortest motorable distance to be 76 kilometers. Though the respondent protested by submitting various representations on 29/7/2017 and 25/9/2017, but to no avail. Based on that, recoveries were made from him with respect to calculated on the newly assessed distance of 74 kilometers. But such recovery was limited from 29/4/2017 to the extended period of contract with the respondent till 22/7/2017. Stop. An amount of rupees 25 lakhs was recovered from the respondent. Stop. Thereafter, by order dated 5/12/2017, the Assistant General Manager of the Appellant Corporation issued a no demand certificate. Confirm. Thereafter, the order passed. Thereafter, the no demand certificate issued by the area manager FCI was accepted by the Assistant General Manager of the FCI, who also confirmed and agreed for refund of the security deposit to the respondent. The security deposit of the respondent was also returned to him. True it is that the appellant did, true it is that the respondent did not challenge the imposition and recovery of rupees 25 lakhs for the reason that it was calculated from 29/4/2017 when the report was submitted about the distance between two destinations. Till the extended period of contract with the respondent. This obviously meant that the roadblocks, the hindrances, diversions were removed, and later, at the time of assessment, the distance was shortened. However, it appears that later in the audit, in the internal audit of the Appellant Corporation, bracket FCI, it was found that the respondent was wrongly paid the bills raised by him on the basis of the distance between two destinations to be 90 kilometers. Since on 29/4/2017, the distance had been reassessed at 76 kilometers. Thus, a further demand notice of rupees 2.11 crores was slapped on the respondent, which was recovered from the other contractual dues of the respondent with the appellant corporation. Stop. This was challenged by the respondent before this court by writ petition, by writ petition number by writ petition by WPC 66 of 2024, wherein the learned single judge found such decision of the appellant corporation to be absolutely unjustified, arbitrary, and beyond the terms of the contract with the respondent. Stop. The learned single judge took note of two conditions of the tender, namely clause B2, B bracket Roman 2, and clause 18, Roman 18 bracket A. For the sake of completeness, we deem it appropriate to extract the aforementioned two clauses. Take it from page 18 and 19 of the impugned judgment. A bare reading of the aforementioned clauses indicate that even though distance between two destinations were provided in the tender paper, but a tenderer had to be satisfied after acquainting himself by visiting the sites that the correct distance was being agreed to, semicolon, for no tenderer otherwise would be entitled for any compensation arising out of any misapprehension in this regard regarding the distance. Stop. In fact, a tenderer was supposed to get acquainted with the conditions of route to be taken by him for transportation of goods. And once tender was submitted, the tenderer would be deemed to have fully acquainted himself with the route, and he would not be entitled for any compensation on account of road blockade, divergence, etc. on the route. Stop. It appears that the respondent did not disagree or raise any objection with respect to the distance cited in the tender, that is 90 kilometers, which was agreed to by the respondent without a demur. Stop. The respondent discharged his contract successfully, and therefore the period of contract was further extended for a little more than 1 month. Stop. During this extended period of contract, some steps were taken for assessment of the shortest motorable route between the two destinations, in which it was found that the distance would be 74 kilometers and not 90 kilometers. This assessment was post the discharge of the contractual obligation of the respondent. The assessment did not disclose that such distance was always, such reduced distance was always available to a motorist between the two destinations. The communication between various authorities of the corporation indicate that indicate that a assessment was made with respect to the distance, taking into account the diversions, roadblocks, and road conditions also permitting big sized lorries to ply on such distance. First up. This therefore presupposes that the distance between the two destinations were not always 74 or 76 kilometers, but because of diversions existing earlier, the corporation, the appellant corporation, on a safer side, assessed the distance to be 90 kilometers, with which the respondent as a tenderer did not have any objection. First off, the question therefore is whether the question with which the learned single judge was confronted with was whether after the completion and discharge of the contractual obligation, such assessment of distance could be varied or changed or modified to the disadvantage of the respondent / tenderer. A look at clause 18A referred to above would again not justify any escalation or reduction under any count, and such terms of the contract, though heavily loaded in favor of the corporation, could not have been used to the disadvantage of the tenderer / respondent. In contractual obligations, the principle of contra pro frentem applies, and therefore the learned single judge in his assessment found that it was absolutely unjustified for the appellant corporation to have recovered 2.11 crores from the respondent as an overpayment because of the wrong assessment of distance. The learned single judge concluded that the distance was provided in the tender paper by the appellant corporation, which was never objected to by the respondent. It was also not clear to the learned single judge as to under what authority or under which provision of the contract, a fresh assessment of the distance of the two destinations was undertaken by the authorities of the appellant corporation, and for what purpose. Be that as it may, fortunately for the respondent, initial deductions were made from the date when such report of lesser distance between two destinations was reported. And therefore, the respondent in his wisdom and fairness did not object to the same. The demand notice, the later demand notice after 5.5 years of the discharge of the contract and return of the security deposit of the respondent was found to be totally unjustified. The manner in which the money was recovered from the respondent was also castigated upon. Under such circumstances, the learned single judge directed for refund of rupees 2.11 crores to the respondent within a period of 45 days, failing which the appellant corporation would be liable for 9% interest thereupon. there is another side to the coin which also need be noted by us. First up, if the distance between the two destinations where the goods were transported by the respondent under the contract was less than 90 kilometers, comma, the respondent was overpaid as the bills were raised on the basis of per metric ton goods per kilometer. But in the present case, there is nothing on record to indicate that for the period that such distance was billed for and paid by the appellant, comma, it was 74 kilometers and not 90 kilometers. There are chances of, there is a fair chance of distance of 90 kilometers being the correct distance between two destinations. So far as shortest motorable route is concerned, or else such an assessment would not have been made by the appellant corporation in the first instance. First up, with the repair of the roads and removal of hindrances and road blockades, comma, the distance may have lessened, the shorter distance may have lessened. First up, that but would not justify any recovery for the earlier bills raised and paid to the respondent. First up, the unjust, it does not appear to be a case of unjust enrichment of the respondent. And even if it does, comma, the appellant corporation is to be blamed for the same. First up, the reasoning given by the learned single judge appears to us to be unassailable. First up, it is trite. Now, it is almost cadet question now. It is trite now that in appellate jurisdiction, if two views are possible, comma, it would not be necessary to substitute the other view unless the view adopted by the learned single judge is found to be perverse or illogical. Stop. Taking into the facts in the aforenoted perspective, we do not find any reason to interfere with the judgment of the learned single judge. Stop. We, however, modify the judgment only to the extent that if the refund has not been paid up till now, refund has not been made up till now, refund to the respondent has not been made up till now, comma, the same shall be done positively within a period of 60 days without incurring any liability to pay interest thereupon. That's the maximum, Mr. Roy.
Deeply blessed.
Item number 3.
May it please, Your Lord. This is a writ appeal against my lord. The order dated 4/12/2023. The issue regarding my lord provincialization, the case of the petitioner for provincialization was rejected by the state level committee on the ground that my lord, their name did not appear in dice code for the year 2000.
1 second, Mr. Katniar. I think there is, let's see the impugned judgment.
Yes, my lord. Page 129, my lord. Paragraph 2.
Where did this joint committee come from? There are two committees that
Yes, my lord.
the provincialization rules of 2017
Yes.
conceive of, the district level and the state level.
Yes, my lord. Under the act, there is no concept of joint committee, my lord. It is admitted position, my lord. But
How
for the,
can the
for
joint
the
level-
purpose of verification, a committee was constituted, my lord. But the decision was taken by the SLC. This is not the decision was taken by the joint committee, my lord. Only for the purpose of verification, that committee was constituted.
First by TLSC, then shall upon scrutiny prepare a list. And thereafter proceed to scrutinize and verify the service records of all teachers. Would then identify a base for each category and recommend the name to the teacher. What is the full form of DISC data?
District information for
District information on school education, and UDIS,
unified district information for school education.
district information.
Information system for education. District information.
System.
No, you can tell it. Required that the enrollment in a particular school shall be verified with the data. As per the DISC code 2009-10 or before, उसके बाद कुछ नहीं, खत्म. There is no requirement under this act to have verification of DSI. उसमें था नहीं. Yes, Mr.
Yes, madam. The only issue is, madam, whether the dice data for 2011 and 12 is required to ascertain whether the
10, there is no such DISC.
that is the
It says, in fact, the rule says that
Or-
after that it shall lose its relevance.
yes, madam. For
So
9 and
DISC data means nothing here because the district level committee scrutinizes. Then physical verification is made by the state level committee. The DICE data is only till 9, 10.
9, 10, 40.
That is to say that because the provincialization rules of 2011 were struck down, 2017 came into existence. There was a memorandum also deciding the procedure in which it has to be done.
Yes, madam.
So it related back to an appointment which was there from 2010. Beyond that, DICE data did not have any relevance.
Yes, madam. There is a relevance, madam. That is why, madam.
Joint committee says that has it been captured in the DICE data?
Yes, there is a relevance. That is why, madam, this appeal is, we have filed, madam. Madam, kindly come to section 4.
Who appears for the respondent?
Mr. H.R. Chaudhary, senior advocate, he was there, but
Who, Mr.?
H.R. Chaudhary, sir. With on lakhs, he'll be coming.
Yes.
Section 4, my lord. Page 115 of the book, my lord. Education manual,
Page 115.
of the education manual.
Yes.
Here. Teacher.
Hmm. Yes,
Teacher and oblique or tutors to be government servant. 4.1. Then 4.2, my lord, there are conditions. The teacher and tutors to be provincial under this act. 1. Must have been working as a teacher in the concerned venture educational institution as mentioned in section 3.1.1 that have been recognized by the competent authority on or before 1/1/2006.
but where are you reading? Clause 4.
Section 4, subsection 2.1.
The teachers and tutors to be provincialized under this act must be working as a teacher in the concerned venture education 3.1 that have been recognized by the competent authority on or before 1/1/2006. Must
That
have
might-
minimum educational professional qualification. Okay, that's right.
3 is relevant for us, my lord. Subsection
6
3.
years.
6 years. So to determine whether the petitioner was working for continuous period of 3 years, we need to verify the DICE data, my lord.
And where is this DICE data? DICE data is for which school? Where is the DICE data reference? Where do we find?
Yes, 107, my lord. For venture lower primary school, 107, the definition, my lord.
107.
Yes, ZB.
Venture lower, these are venture lower primary school.
Yes, my lord.
No, these
Yes.
respondents are lower primary school teachers.
Yes, yes, my lord.
So this says that it should be DICE code up to 2009.
9 and 10. It's for the school, my lord.
This is for school. Now, what does the proviso mean?
Provided,
Provided that the DICE code shall have to be issued on or before 2009, 2010. And DICE code issued thereafter shall not be considered for the purposes of
Yes, ma'am.
provincialization of services of any employee of the institution. What does this mean?
my lord, if DICE code was issued after 2009 and 10,
Hmm.
retrospectively, that will not be considered, my lord.
नहीं, but इनका capture तो होना चाहिए था ना। क्या- and also the teacher, no? The imparting education up to class 6 and established whose names figure in dice code, and prior to that and whereof the services of the teachers have not been provincial. The services under any. But Mr. Khatnia, tell me one thing.
Yes, my lord.
Now, this is school,
Yes,
this school, which was to be, I mean, this school which had to be provincial,
Provincial.
services had to be provincialized, the school also
yes,
has to be provincial. That must be there in DICE code 2009, 2010.
yes, my lord.
That is there,
Up to 9, 10.
but then this does not refer to teachers.
Yes, my lord.
It doesn't.
No, my lord.
It doesn't refer to teachers.
Yes. It doesn't refer to my lord.
It doesn't refer to teacher. So why does, I mean, what is, the joint committee says whether the name of school appears in DICE. That's right. That's correct.
Yes, my lord.
But whether the name of incumbent appears in DICE data of 2011.
11 and because my lord, and under says 413, my lord, there's a requirement to have the continuous service for
6 years.
6 years.
So that
Because
is by
if it,
physical.
if it is
that is
appeared
by
for 11 and
physical
12,
verification.
sorry, my lord.
Which quota? Where is the DICE for teachers? DICE record,
Yes, my lord.
DICE categorization or DICE record is for the schools.
Yes.
Where is it for teachers working?
In the act, my lord, there is no requirement, but we have to verify, my lord, whether the concerned person was actually working
That
or not.
verification is not by way of their names being captured in DICE.
Because, my lord, to capture in the dice data, it is compulsory, my lord. It is compulsory, my lord. For each school,
Oh, that
They
is
must have the DICE data, madam. For teacher also?
कैसे करा है कि देखो? How is- यही तो जरूरी है। हाँ, ये तो पता है ना करता। And why, where has the judge said that it is not necessary apart from joint committee?
yes, my lord. Paragraph 10, my lord. Paragraph 10 starts from page 136. My lord may skip the first part.
Hmm.
Page 137. Line from my lord.
Read paragraph 10.
Yes, my lord. The concept of joint committee is not provided for the provisions of the Assam so and so act, and the said act mandates only two-tier consideration.
So right, that we understand.
And
Is
that-
that joint committee not being an authority?
yes,
Is
sir.
that the only ground?
This one, if line start from my lord, even if, my lord, even if. Sixth line.
Hmm.
Even if it is held that the joint committee has the jurisdiction to examine the proposals and provincialization of the service of the teachers under the so and so act.
The data.
The
that has-
data that has been called for, that is DICE data from 2011 and afterwards, and the enrollment position of the school during 2016 and 17 and 17 and 18 is clearly contrary to the requirement in this connection as made in the said act of 2017. The provision of section 311 of the so and so act requires that the enrollment in particular school shall have to be verified with the DICE as per the DICE code 910 or before. There is no requirement under the act to have verification of DICE code after 2009.
And then their names did not find mention in 11.
Yes, my lord.
So therefore, you say that how to confirm that they were continuous in service?
Exactly, my lord.
They may have joined there for 500 rupees, 400 rupees. They may not
Exactly, my
have.
lord. Exactly, my lord.
Oh, your dice तो कहता है ना कि it cannot be for the purpose of harassment. Continuous service. Dice वाला कहाँ पड़ता है इधर? बस फिर से नोटिस पे तो ही है इसका कौन सा पेज था तो इसका कौन सा पेज था Dice determination concept is not good for that. 10. मतलब 4 साल ये स्कूल रहना चाहिए। No, but the proviso has to be read again.
Proviso ZB.
The proviso of ZB will have to be read again.
Yes, ma'am.
Now you are looking for his name
Yes,
in DICE 2011,
yes.
Hmm?
Yes, ma'am.
but that is not the requirement, no? At least what I understand from the proviso.
Under the act, this is not a requirement,
no.
madam.
Just a
but-
minute, read this.
Provided that dice,
Read the entire ZB.
yes, madam. Venture Lower Primary School or Venture LP School means a school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figure in the dice code up to 2009 and 10, and prior to that.
Therefore, a school must be in existence in 2009 and 10,
Yes,
and it should continue from 2006,
yes,
1/1/2006.
yes, ma'am.
Thereafter, no need of any dice capturing of the presence of the school. And prior to that, and whereof the services of the teachers have not been provincialized also, provided that dice code shall have to be issued on or before 2009-10, and dice code issued thereafter shall not be considered.
Yes.
Therefore,
This
any
is
dice code issued thereafter, this is for this proviso, you mean to say that it is only for schools and not
yes,
for the
yes, madam.
teachers?
Yes, madam.
It is only for the schools, not for the teachers.
Yes,
But
madam.
where is the provision for teachers?
Teachers, that provision is not there in the act.
And then where are
But-
you looking for?
No,
How
madam.
are you looking for?
Because, madam, dice is the only digitalized data, madam, from which we can confirm.
Sir, the question is this.
Yes, madam.
DICE data confirms the presence of the school with the teachers and enrollment.
That is why, madam, because from
Just a
2006
minute,
to
you forget your position as a standing council for the education. We are trying to understand it from you. DICE data captures the school's presence along with the pupils and teachers working. Right? So 2009-10 data, it began from 2009-10 data would tell us that the school is in existence since 2006. A school is in existence for about 4 years.
yes,
Teachers, of course, the school capturing of school captures the number of teachers, number of pupils also. And thereafter, when it says that the code itself shall not be considered, then why are you looking for DICE 2011 for testing whether these persons were in continuous service for 6 years?
this proviso is for the purpose of retrospective operation of the dice data, madam. Because sometimes,
How do you read it like this?
because sometimes, madam, some schools have obtained the,
Before 2010. Thereafter, there is no DICE code which will say that teachers, for a school, no DICE code. There, after 2010, there will be no DICE for schools. One code. It will speak school. That's all right. So it should have, that will continue now. So therefore, if that time, you had to capture, was it there in 2010? Yeah, 17 में हो रहा. To know whether there is a provision for capturing of the teachers, the enrollment of the teachers in the school in DICE every year.
yes, it is there in the dice information system, but in the act, it is not there. There is no provision in the act because this act is for purpose of provincialization, not for dice, my lord. We are taking dice to ascertain whether the school are or in existence or not.
They were there.
I can
And
provide,
the
I can
district
provide,
level committee said what with respect to them?
district level committee recommended their case, my lord.
No, on the basis, on what basis?
My lord.
अभी provincial level को Take it. No, no, okay. They have not, they have been disqualified.
My lord will find it at page 98,
Let's take. Page 98 of.
98 of the appeal memo, my lord. This is a report in respect of one school, my lord. 98. This is a recommendation of the district level committee, my lord. There is no mention about the dice data for the year 10 and 11 in respect of the incumbent.
Where do you get page 98?
Page 98, my lord.
Oh, एक
Name of the teacher. Colon 6, my lord. Altaf Hussain and Asabuddin. The enrollment for 2014, 15 and 16. Status of the post, whether first, second or third, first and second. So their case has been recommended. Page 99. My lord will find the signature of the chairman of the district scrutiny committee and member secretary.
Where are you people now?
We are
What?
there, your lord.
Huh?
We are there, your lord.
Where? In the school?
The school, your lord.
But you are not getting payment.
No.
How come they are being continued in the school?
Because it's a venture school, my lord. It's a venture school. The school has yet not been provincialized, my lord. Because the two teachers are working there. Both are not eligible to be provincialized.
No other proof would be required except dice.
Yes, my lord.
Fine, big deal. That will be- That's all. Take it. There's no question. Yeah. There's no question. Yes, Mr.
Lordship. Lordship has kindly noticed and in fact gone through.
No, no, we were noticing it from the point of view of teachers. Now we have noticed it from the point of view of, true it is that joint committee is some super power committee. I don't know, they have constituted for what purpose. But the efforts are only towards, verifying whether you were in continuous employment in this school for 7 years. Right? And if you were there, your name should have been there in the code in 2010, 2011, 2012. But if it is not there, then how to justify? Because that is one of the essential conditions that you must be in employment for the last 7 years. The reason is that the government is going to just, make you a government employee. No questions asked, no tests taken, nothing of the kind. So this carefulness is necessary, whether by joint committee or whichever committee. We will hear you sometimes, but we'll have to stay this judgment, stay the operation of the judgment.
Lordship.
We'll hear you on Sunday, sometimes in January. Take it.
We'll fix a date.
Hmm?
We'll kindly fix a date.
Yeah, we'll be fixing it. Can I have your name, please?
MH Loskar.
Would you like Mr. H.R. Chaudhary also to be here? Now, because we are staying the operation of the judgment. He shouldn't say that,
He is on lax, your lordship. Actually, appeal has been filed after 1 year of filing of the contempt. When the contempt was filed, then they appeared and said that lordship is confirmed, correct, but that appeal was filed after more than 1 year of the impugned judgment, your lordship. Only when the contempt was
see, the
filed.
difficulty is that if we allow this on that slender ground, that's a good ground. Otherwise, had it been, if it would have impacted 1, 2, 5, 10, 100, you'd have taken that ground to be a tenable ground. But this way, the list would be endless.
No, there are no other schools with this difficulty, I think, that have come because provincial is done one back in 2020. Now we are in 25. Only this case is pending, your lordship, on this ground, on this issue of no other cases are there, your lordship. And there is absolutely no requirement of 2011-12. In fact, the act says that Dias code issued after 2009-10 shall not be considered for the purpose of provincialization of services of any employee of the institution. That is a very clear and categorical this thing. And so far as whether they are serving or not, your lordship, it is the district scrutiny committee. Lordship kindly goes to section 13 of the act. The district scrutiny committee has been empowered to verify not only the details of the schools, but also the details of the teachers who are serving there, your lordship. The district scrutiny comprised of the deputy commissioner and the school inspector. So once they have made a favorable recommendation, then the state level scrutiny committee has also made a favorable recommendation and the matter was placed before the joint committee, your lordship. And it is only the joint committee that has come with the conclusion that your name is not there in 11-12 and therefore you are not considered, your lordship. Now all these schools are located in tea garden areas, your lordship. And this information given for the Dias code, it is done by the highest level from inspector of schools, your lordship. We don't know whether they have not forwarded the name or what happened, your lordship. But so far as this requirement is there, your lordship, it is not the requirement, your lordship. It is the district scrutiny committee which has been given the exclusive jurisdiction to determine the details of the schools as well as the details of the serving teachers of the school, section 13, which is very specific, your lordship. And that matter was gone into by the learned single judge, your lordship, while dealing with this issue. The act is laid down specified rules. In fact, the office memorandum that they have issued, it is also there, your lordship. That it is the state committee, the district committee, then the state level scrutiny committee.
But then district committee can go wrong, no? District committee can go wrong. This can be very well confirmed. District committee recommended your name. But were you complying with the conditions of 7 years of employment?
Because
How to justify? What do you say?
we have given our appointment letter, we
And
have
this
given
is,
our
this-
joining
and,
letters.
but then you Dias code, if your name were not there, you
In
would have been careful, no?
17-18 again our name have come, 19-20 our name have come.
It is from 17.
Prior to that also,
Therefore, it doesn't take you for 7 years, no? Question is that in 11, you should be there in 11. Your name was not there only for 1, therefore no continuity in service. And that's what is required. That's what is required. Joint committee, the London single judge is right. We have no objections. But how to confirm it? How to say? If you had any other methodology,
page 138, paragraph 12 of the impugned judgment, your lordship.
देखिए ऐसा है कि teachers to be government servants, they must have rendered at least 6 years continuous service as on 1/1/2017. Therefore, the requirement of your name in Dias code of 2011. They are not asking for any other thing. You may be from 17, 18, 19,
No,
but
we have given our appointment letters, joining letters, all these are there, your lordship.
that is private schools, they give certificates.
No,
post-dated.
these are venture schools. All these appointments have to be forwarded to the inspector of schools, your lordship, from time to time.
How can it be justified? Now forget about joint committee report. Was your name there in the court
Lordship, it is there.
in 2011?
11, 12, it is not there.
Then which year it is there?
Some of the name came prior, 7, 8, some name were there again, 9, 10, 9 was not there, your lordship. The dice,
So there was no continuity.
the dice is maintained by them, your lordship. It's not that every year teacher should come and change, your lordship. And so far this issue, lordship, paragraph 12 of. paragraph-
Dice is maintained by them, but that is the only proof. If you're teaching and your name is not there, you must get it incorporated. It's not an ironclad, code.
Lordship.
It's not something like UI, which is that code. And has the district level committee said something that why they are recommending? Mr. Katniar?
No, my lord, regarding their presence of
Mr.
diet.
Acharya Chaudhary,
My lord,
we were waiting.
my lord.
No, no,
I was
I see
waiting here.
I saw you waiting. We were, in fact, one case took a lot of time and your case also. is
I'm
taking a
obliged to
lot of
lordship, I'm obliged to.
Mr. Chaudhary, there are two aspects of the matter. We are aware that your name had been, your client's names were recommended by district level committee. It had to go before the registrar, the director had to send it to the state level committee, which had to make physical verification.
Right.
But before that, a joint committee came into existence.
Right. That is the.
Now,
whole-
we do not find the existence of joint committee to be correct, but then because of bogus claims of many persons, this might be required. So for the moment, we are in agreement with the learned single judge that no, joint committee's existence is non-statutory. We don't acknowledge it. But question is that your name must be there in the DICE code of 2011 for, just a minute, for justifying that you had worked for 7 years continuously till 2017.
11, that statute does not permit my lord. Statute say 2009 and 10. 11, they have been introduced by 11.
2009 and 10 says for the school.
The statute says, my lord, you'll also kindly see.
That I've seen proviso.
Yes, my lord.
That's
Statute says,
because,
my lord.
that is because some school which would be captured by DICE in 2011, that is not something which is going to be taken into account. Because that school DICE should be from 2006. And it should end by 2010.
So,
Thereafter, you remain, doesn't matter. But for the teachers, unless you are in 2011, it says
11 concept, how I come, my lord.
it must have rendered at least 6 years of continuous service as on 1/1/2017. If the district level committee would have found out from the records that you were there,
Yes.
what is the basis?
No, basis from the record placed before the district level scrutiny committee, then it goes to the state level committee. What remains, my lord? How 11 comes, my lord? Where from 11 comes? Why not 14, 15, 16, 17, my lord? Why 11?
11?
My lord, no, statute says 9 and 10.
No, Mr. Chaudhary, again, your
My lord, I am on statute, my lord.
we are also on the statute.
Yes,
It's open before us.
yes.
2011 is wanted for the reason that 7 years should be completed on 1/1/2017.
Right.
Correct. So therefore 11.
7. No, my lord. I'm just wondering if your lordship permit, my lord, that
Yes, every year.
for my knowledge, my lord, your lordship already gone, my lord.
No, section 4.
My
We are
lord,
reading it.
no, I'm told, I'm on the ZB. ZB, my lord,
That we also we read.
of section 2,
We read that.
page 107. This is the book, my lord.
Yes, we are.
Bencher Lower Primary School of Bencher LP School means the school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figure in the DICE code up to 9/10 and prior to that, and where of the service of the teachers have not been provincialized under any act enacted by the Reserve Fund. provided that the dice court shall have to be issued on or before 9/10, issued thereafter shall not be considered so and so such. I fall in this category. my-
Yeah, you fall in the category.
Yes,
But then if it is read with section 4,
yes, section 4, my lord.
423,
Section 4,
that you will get at page 115.
my lord, Roman 2.
Come to page.
Teachers or tutors to government servant
Hmm.
must have, my lord, your lordship, Roman 3, my lord,
Hmm.
must have rendered at least 6 years continuous service as on so and so from the date of joining in the concerned venture
You see,
institution. which-
therefore, the necessity of 2011 dice code.
My lord, it
So
is-
far as school
my
is
lord-
concerned, we are not
My
questioning.
lord, this is with regard to the teachers. Who is tutor, who is the teachers, my lord. This is not to do with the provincialization. Section 4. Section 4, your lordship, subject to fulfill all other provision, the services of the teacher, so and so, venture institution.
This is common for teachers and tutors both.
My lord, now two categories in the in Assam, my lord. One is tutors, one, my lord, teachers, my lord, those regular teacher. Tutor gets some, my lord, fixed pay. Those, my lord, this is regarding teachers, my lord, not in schools.
Mr. Chaudhary, we will hear you, but the judgment will have to be stayed. We'll hear you sometimes in January or
My
February.
lord, my lord, your lordship, these person, some of them already retired, I think, some of them are going.
Mr. Chaudhary,
My lord, I live here, but your lord,
Only
can you see the plight of
only
these people?
because I was concerned for these teachers, therefore we have devoted so much of time.
That's
Otherwise,
true, man. I'm obliged to your lordship, that I'm not, my only question, my lord,
we will hear you once again. Take it on. We have heard Mr. Khataniar, Mr. N.J. Khataniar, learned advocate for the appellant state, and Mr. H.R.A. Chaudhary, learned senior advocate for the respondents. By the impugned, by the impugned judgment dated 4/12/2023, the learned single judge has taken exception to the constitution of a joint committee to vet the report of the district level scrutiny committee with respect to the teachers who had to be provincialized under the Provincialization Act of 2017 for them to become government servants. The requirement under the Act of 2017 is that the names of the teachers, names of the schools and the teachers would be recommended by the district level committee, which shall be verified on, which shall be physically verified by the state level committee, and only thereafter the services of such teachers shall be provincialized. The learned single judge therefore found that when the names of the respondents were recommended to the state level committee for further action in this regard, there was no justification of another round of vetting by a joint committee which is neither statutory nor under any provision of any office memorandum regarding constitution of such committee for any specific purpose. It appears from the records that because the names of the respondents were not captured in the dice code of 2011, therefore, their cases were not required to be sent to the state level committee for their provincialization. Defending the judgment of the learned single judge, Mr. H.R.A. Chaudhary, learned senior advocate, drew the attention of this court to the provision contained in two ZB within quote, ZB within bracket of the Act of 2017, which mandates, which clarifies that venture lower primary school or venture LP school would mean a school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figure in the DISE code up to 2009-10 and prior to that, and whereof the services of the teachers have not been provincialized under any act enacted by the state legislature so far. Then you make a separate line and a paragraph, provided that the DISE code shall have to be issued on or before 2009-10, and DISE code issued thereafter shall not be considered for the purpose of provincialization of services of any employee of the institution. So based on this provision, namely 2ZB of the Act of 2017, Mr. Chaudhary contends that assuming but not admitting that joint committee was only vetting the names which were required to be considered for provincialization, comma, merely because the names of the respondents did not figure in the DISE code of 2011, comma, their cases could not have been kept on the back burner for the reason that for the purposes of provincialization of the services of any employee of an institution, comma, what is required to be considered is their enrollment in DISE code of 2009 and 10 and no further. Stop. This argument of Mr. Chaudhary gets neutralized if one looks at the provision contained in section 4, bracket 2, then Roman 3, which provides that for a teacher or tutor to become government servants, comma, they must have rendered at least 6 years of continuous service as on 1/1/2017 from the date of joining in the concerned venture educational institution, which must be on 31/12/2010 or prior to that date. Precisely for this reason, comma, the joint committee looked for the names of the respondents in DISE code of 2011 to ensure that the names recommended by the district level committee are of such teachers, tutors who have continuously rendered service for 6 years, to be 6 years as on 1/1/2017. Stop. There could be no other purpose for looking at their names in DISE code of 2011 and not of 2010 or of a later code. Stop. This was only to ensure that they were in continuous service for 6 years for them to be eligible to be considered for being made government servants. Stop. From the impugned judgment, we find that because the joint committee has not been conceived of in the Act of 2017, therefore, the learned single judge found the derailment of the process at the level of joint level committee to be dehorse the act and the rules appended thereto. Stop. the matter requires, the issue requires to be heard. We admit this appeal.
Or your lordship may remand this matter also, madam, giving this suggestion, keeping in, your lordship has allowed it in the plantation manner. Your lordship may say remand the matter, that will also some time may be said, ma'am.
To whom? To whom? Joint level committee of
No,
question?
no, madam, single judge, what am I, you're keeping those our lordship observation. Because somebody is to say, madam, whether local officer, district officer, or that, whether they're working or not, school headmaster, other things are there, madam.
ये बहस करेंगे आप. This is an issue of argument.
Yes.
This is a rule of, this is something which you can argue. That if you have any doubt, you find out from the school, you take the records,
exactly,
make
ma'am.
physical verification. Don't ask.
They may bring the information to school, that's enough, my lord. The director can do it. Why join the committee? That is the, I think, concept, madam, that we.
No.
You bring it, the director also may bring information.
You furnish report.
We can. We also can do it, my lord.
So bring it. We are fixing a date in January. Not, this will not be without, we'll fix a date. It will be listed on that date. This requires to be heard.
In January. Prior to
January.
Christmas, might be possible, madam.
Huh?
Let us, prior to Christmas, madam.
Prior to Christmas, I don't think you'll be able to find out. You will not be armed with necessary papers to support your case. I'm giving you good time. January, where is the January calendar, tentative calendar which we have?
Madam, we have filed additional evidence that will not annex, madam. We are having with this, madam.
No, we fix a date.
We have given all the certificates, madam. That is not annexed with the petition, appeal, madam.
We might ask the state level.
Yes,
committee
again,
to
we can file, madam, no problem.
But Mr. Khataniar,
Yes,
sir, the state level committee should see and decide.
That is
Anyway,
the-
we'll deal with it.
That is,
We will deal with it. But for the present, we'll have to stay the operation of the improved judgment.
Once, I lift you, but once you also stay, madam, again, time,
We are conscious of this fact.
So-
We will not allow
one,
them.
if possible, one date may be prepared, if possible. I lift your lordship, if convenient to your lordship, madam.
We are fixing a date in December. I have not, December में सुन लें.
Well, November has not come, my lord.
क्या लिखा है पढ़ो? The issue requires to be heard. This appeal is admitted for hearing. List this case for hearing and final disposal on, give a date, January 2nd week, January 1st week. Mr. Chaudhary,
I,
8th January,
on 8th of January.
8th of January.
8 of them.
In the meantime, the operation of the impugned judgment shall remain in state.
And respondent may be at liberty to bring the records
That-
before.
We accept it across the board.
That's, records will on a single judge also may be. That will be.
Just a minute. वो wait करें. देखते हैं. You see, allowing this judgment to remain on board or not to, this could not have been
No, no,
complied with.
madam, your lordship,
So we will finally
that is
decide.
better, your lordship is to
It
decide.
is better that we hear it,
Madam.
otherwise they will never do it. If we dismiss his appeal, they'll go to Supreme
That's
Court
what
and
it
it
is.
shall be
Fine,
stayed.
madam,
No, because Department of Education is the worst hit department either ways. Everywhere, all over the country.
Yes. Assam is not exception, my lord.
We admit this appeal. List this for final hearing and disposal on
8th January.
8th. Would you be ready or second week of January?
Second,
Huh?
third. Second week.
After. Come after you, third week of January. Third week of January.
Provided I remain okay, my lord, help me.
Provided. What happened to you, Mr. Chaudhary?
No, my lord.
You shall be here for many more years, don't worry.
At least I can look to you.
If you choose to travel to some other place, become a MLA or minister, then perhaps we'll.
But I lost my
I'm notifying on 21st of Thursday को कर देते हैं. On 22nd of January 2026.
Madam.
Till such time, the operation of the impugned judgment shall remain in abeyance.
Obliged to.
वो calendar इधर है, बहुत लंबा समय लग गया.
Item number 4.
The pleadings are over, matter has to be heard. Finally, I'm ready, my lord, your lordship, I will not take much time.
Give us the judgment with respect to the cases where, because the legal heirs have not been noticed, therefore entire proceeding is bad. But otherwise, why do we hear you now?
Okay, well, my lord,
Yeah, what is
Garnet
this?
single judge, this is a different case, promotion matter.
Oh,
The
acha, acha.
petitioner was
I looked
promoted
at number 4. This is item number
4.
4. What is this for?
My lord, this is for final hearing, it has to be heard, the matter has been, my lord, all the pleadings are complete. Only one issue is there, my lord. My lord, the petition-
No. Correct. Sir, you come to the impugned order. Why hearing now? Let us see the order. We'll do it now.
Yes, 135, page 135.
Legal.
First, my lord, writ
legal
petition
aid
was
to
allowed,
notice
this is in,
Doesn't matter.
after the review, this order was passed.
Now, this is tribunal. Let's see tribunal's order.
Not tribunal, there is no tribunal, no, single judge order is
Single
there.
judge order.
Single judge order, your lordship will kindly, initially it was passed. Page 65.
Promotion.
Promotion, yes.
Yes, grade 4 to grade
Yes,
3.
item number 4.
No, I'll just give you the facts, my lord. 2018, my lord, they-
Teka.
Yes.
What I find, my lord, page 140, my lord, that is my grievance. Page 140, paragraph 14.
ये हम कहाँ से देखें? दोनों पूरे नाम है. Item number 4.
The judgment was passed, my lord, without giving opportunities to us. I'm not on that, I'll go on the merits. Paragraph 14, that is not on the
Or we can have it.
correct law.
The pleadings are complete.
Yes.
Here. The pleadings in this case is complete. Let this matter come up for consideration under the appropriate heading on the 22nd of January. Along with this case, along with the interlocutory application. That way, yes.
Item number 7.
Please, your lordships, I beg to appear through VC, your lordships, for
Yes.
petition.
Yes.
Your lordships, here I'm against the order of Learned Cat, where they say an individual cannot get disability pension and invalid pension simultaneously. Your lordships, I will take my lords further to impugned order, your lordships. It's a page
Now,
number,
before impugned order, you will let us know.
please,
As I understand, and we may be incorrect, you'll have to educate us.
please.
Now, invalid pension and disability pension are mutually exclusive.
Please, your lordships.
You can't have both.
I will take my lords to even CCS pension rules say so. Both pensions are distinct. If your lordships.
That's what
may
we
have
say.
taken-
Both pensions are distinct. In an invalid pension, you may get a disability component. Or in a disability pension, you may get a component of invalid service, service tenure. But then it can't be merged together totally. You on your own, therefore the documents which you asked for, yes, show us the rules
Please, your lordship.
and give us the judgment. As we understand, it can't be two pensions together.
Your lordships, disability pension have two components, disability element and service element. So here
All right.
I'm entitled for disability elements plus invalid pension, which I'm
Therefore, therein, madam, lies the confusion. You are Pallavi Avasthi.
Please, your lordships.
MS Avasthi, there is the problem. Suppose disability pension when you are getting, forget about invalid pension.
Please, your-
Disability pension, if you get, this disability component is calculated,
Please, your
correct? This
Please.
disability component, say maybe it is 20%, 30%, 40%, less than 20% you don't get.
Please,
So
Your
this
Lord.
disability component is 20%. No pension can be calculated only on the component. Your length of service has to be counted. Correct? So
For
this is
disability pension only, invalid
just a
pension,
minute.
Your Lordship.
Therefore, try and understand it's a common sense apart from, legalistic formulations. These are common sense principles. So suppose you had worked for 7 years in an organization, in a company, in Air Force or whichever, and then you are, you acquire one disability which is attributable to your work,
Please, Your Lordship.
or it got aggravated by your work. So
Please.
you get a disability component.
Please,
So
Your Lord.
in this pension, what you are getting, this is the length of service plus disability.
Please, Your Lord.
Correct? So
Correct.
this is disability pension separate block. When you
Please.
say invalid pension is when it has got, when the invalid, when you have been invalidated. That's an expression which is used in case laws, but I don't think it's a correct correct expression of invalidated.
Invalid.
When you become invalid during the course of service, which is not at all attributable to your job profile or your office work. Suppose you develop rheumatoid arthritis
Please, Your
and
Lord.
you're a safai wala, as is in your case. You're a cleaner and you suffer from rheumatoid arthritis.
Please, Your
You
Lord.
say that you can't work now because of your blocked, joints. You get an invalid pension. But you can't combine invalid pension because you leave service because of that, and then disability component also. Where is the attributability to this? I don't think you have a case. Yes, now tell us.
Your Lordship, but they say my disability is attributable to service. There is medical document, and before that, Your Lordship, I will take my Lords 2 for a moment at page number 106, Your Lordship. This is CCS Pension Rules, Rule 38, which has been amended in 2022, and this has become Rule 39. But rule is same, language is same, Your Lordships. It says 106. Para 2, Your Lordships. May I read with permission, Your Lordships?
Now, what is this paper?
This is CCS pension rule, relevant extract
We
of
don't, we don't read rules like this when you extract it from some place. Yes, we have the rules. Yes.
Then my lords may have a main letter 7th August 2001, which has been referred and which has been said by the Learned Cat that it is an overdated OM. Your lords, the very next page 107, my lords may have this office memorandum 2001.
Anyway, you read the second paragraph of page 106.
I'm so grateful. Disability pension and invalid pension are distinct, and the minimum limit of rupees 1,275 on the total of 2 pensions does not apply. With reference to this department OM number so and so, now on the subject, representations have been received from various pensioners associations and individual pensioners who are in receipt of more than one pension, like disability pension under the CCS EOP rules and invalid pension under the CCS pension rules, against application of minimum limit of so and so to the total of 2 pensions as indicated in para so and so. The said OM, the matter has been examined in this department, and it has now been decided that the element of disability pension and invalid pension may be treated as distinct pensions, as was the case prior to 5th CPC. The invalid pension may continue to be regulated as per CCS pension rules subject to the certain minimum amount, and the extraordinary disability pension may continue to be treated as a separate element, and this should be fixed as per the degree of disability. This will not be subject to the further condition, and the amount of disability pension and invalid pension should be in no case exceeded the last pay drawn. Then your lordships may have para 4, Ministry of Agriculture, etc., are requested to bring the contents of this order to the notice of head of department, controller of account, pay and accounts officers to attach so and so. And there is mentioning of this OM 7th August 2001, which has been annexed on the very next page, your lordship. This 7th August. And the Learned Cat has said that this OM of 2001 is outdated That is the only reason my OA has been dismissed, your lordships. Your lordships may have this OM on the very next page, 107. Your lordships may have it.
Just a minute.
The very same language has been repeated here, your lordships.
He may have, the tribunal may have said that it is an old OM which has outlived its utility and much water has flown in the Brahmaputra and the Ganges both.
Please, your lordships.
I mean, that's something different. But the law is very clear. You can't have two pensions.
Just
Check
one
it.
submission, your lordships. Even they have relied on a communication dated 3rd January 24 passed by PCDA, your lordships. PCDA is only a pension sanction authority, whereas I'm sorry.
Yes.
Air headquarter has already sanctioned me disability pension. If your lordships would have page number 60, there is a calculation given by Air headquarters. But the learned cat has relied on a communication passed by PCDA by superseding the OM dated 2001 and the CCS pension rules, your lordships. Your lordships may have page number 60. I'm sorry, page number 66, your lordships. Page Annexure 17, it starts from page 65. There is the calculation which was given by Air headquarters. They have sanctioned my case for disability pension along with invalid pension, your lordships.
Correct.
Page 63, when it starts from
Valid pension. Page 66, yeah.
page 66 is the calculation, your lordships. It has been issued by Air Force, Air headquarters, your lordships. Calculation of disability pension. There is some calculation, though I'm so sorry, I'm failed to understand this method of calculation. But there is calculation. They have sanctioned me disability pension along with this invalid pension, your lordships. And Learned Cat has not dealt with this issue, with my entitlement. They have simply said that OM is very old. And even that is existing as on date, your lordships. Page number 63 also has been issued by Air headquarters.
No. Your case has been recommended by one Mahesh Kumar Singh for disability pension.
Please, your lordships. Issued by Air headquarters on top, your lordships.
And that is no ground.
Then your lordships may have page I will take my lords again to impugned order. There is one clause under para 6, your lordships.
Which is you can lose point for me. Huh? Huh? Is she concerned rule to no, ठीक है, ठीक. Ordinance पे. Ordinance का. 39 pump. 49. इससे हम लोग को मतलब yes.
If I may take my lords to impugned order, para 6, page number 115, your lordships.
Yes.
It says, your lordships, here Learned Cat has dealt with the letter dated 24th, which was relied by the other side before Learned Cat, your lordship. It says, also the senior CGSC has placed on record a letter dated so-and-so 3rd January 24 issued by so-and-so account officer, office of the PCDA, Prayagraj to OIC so-and-so, which reads as follows, your lordship. The disability pension consists of 2 elements. One is disability element.
That we have read. You don't read it further for us.
I will read only one line for convenience of your lordship. Just it will start from the bottom of this page, your lordship. However, she may be eligible for disability element, then turn over the page, my lords. Element of disability pension if she was invalided out from service due to disability aggravated by the service.
That is what we have been saying right since the beginning without opening the file.
Please, your lordships. So they are saying in 24, your lordships, in communication dated 24.
Anyway,
that
they are not inclined to interfere. Take it down.
then
We
your
have heard-
lordships may give me some time to produce some judgments over the issue, your lordships.
You
if
should have done it now after spending so many minutes. You challenged this order before the Supreme Court. What judgments? You should have brought the judgments here.
I'm not attending the court physically today, your lordship. So I was supposed to come today, but I'm due to some health issues. I
Anyway,
couldn't come.
we will grant you one more day, but we will record our
I'm so
initial observations. We can't just pass it over like
I'm-
this after spending so much of time.
Please, your lordships.
Today, this is the third day. Anyway, we have heard Pallavi, we have heard MS Pallavi Avasthi, learned advocate for the petitioner, and Mr. Chakravarti, learned Central Government Standing Council. Central Government Standing Council. Stop. The petitioner has questioned the order dated 6/3/2024, passed by the tribunal, rejecting her claim for getting disability pension along with the invalid pension on the sole ground that her condition of rheumatoid arthritis was aggravated while she was in service. Stop. The records reveal that the petitioner worked as a cleaner in Indian Air Force, from where she took invalid pension for having suffered rheumatoid arthritis. Stop. On her claim, she was given the invalid pension. Stop. Later, she claimed for disability pension also, which was estimated at 40%. Full stop. The tribunal took note of the fact that invalid and disability pensions are mutually exclusive, and a person cannot get both the pensions at one time. Full stop. Invalid pension is meant for providing succor to a person who during the course of service is rendered invalid because of any ailment or terminal illness. Stop. This is different from disability pension, where the disability is incurred. Disability is incurred by an employee, which is solely attributable to the job profile. Stop. This would also include aggravation of the disability while remaining in service. Stop. For the payment of disability pension, the length of service and the percentage of disability are counted in a rational way, which counting is provided in the CCS rules, in the pension rules, in the relevant pension rules. Stop. What the petitioner demands now is that she is getting invalid pension for her having developed rheumatoid arthritis, but now, but with a doctor having confirmed that this situation aggravated, this illness of this disease of rheumatoid arthritis got aggravated while she was in service, comma, she is entitled for being paid disability component in her invalid pension. Stop. The tribunal rightly rejected her prayer, rightly rejected the prayer of the petitioner on the ground that a person cannot have these two distinct pensions in one distinct pensions simultaneously. Stop. We were about to dismiss the petition, but considering the young age of the learned counsel who has requested for another occasion for her to cite some judgments, we adjourned the matter to which date? Tell us. We can't hear you. You have to unmute yourself.
9th of December, if convenient to my lords, 9th of
December.
I'm so grateful. I'm so grateful, your lordships.
All right.
I'm so grateful.
Supplementary list for admission, item 26.
May I please, your lordship? Lordship, my grievance is only that interim protection has not been given, lordship. I have been selected provisionally for admission in Guwahati Medical College under PWD quota. On 25th,
1 second. Give us a minute. Shows the requirement where your certificate has to be assessed by a medical board.
My lord,
Shows the requirement under the law.
my lordship, my
Then
concern,
we will direct for keeping one seat reserved for you, subject to the outcome of
My
this
lord,
writ petition, but otherwise not.
Sir, I have the disability certificate, which I have annexed as Annexure 1.
Wait,
writ petition.
I'm asking something else. Try and understand the question of the bench. Then only you'll be able to answer.
Mhm.
You have an eligibility certificate of 40%.
Yes, ma'am.
40% disability, not eligible, 40% disability,
Yes, ma'am.
right? It was subjected to a medical evaluation later,
Yes, ma'am.
and it was found that the disability is 18 to 20%, and therefore you don't fall in the category. Now, where is the law? Where is the rule under the PWD Act that when you offer a certificate, it will not be accepted as such, but it will be vetted, evaluated.
My lordship,
That's the only case of yours.
as per the
That
act.
once it has been given, it cannot be
Yes,
re-evaluated.
ma'am. As per the act, the certificate has been given. If it has been not accepted, then it should follow the act according to which it was
On
given.
this material, we cannot possibly
lordship,
grant
and,
that indulgence.
On 25th, I appeared. RPWA question. RPWA question.
That is the question which I asked. How?
Section 32 of the RPWA Act 2016 is relevant, my lord.
Section 32.
Yes, my lord.
No, post would be reserved definitely.
Yes, my lord. No, guidelines and assessment of specific disability. And Rule 19 also is relevant, my lord.
That's okay. You're referring to? Chapter 10 of disability. No person to establish.
Rule 19 may be seen, my lord.
They must have identified seats of for disabled category, provided comes with that. This certificate is not, it has to be vetted for the taking up. Employers and the examination body. Like, where is this? Just.
My lord, Rule 19 is relevant.
1 second. He was provisionally selected. Medical board at 40 medical set. Let's see the, have you annexed advertisement? The advertisement for the post,
My lord, not post, my lordship.
admission in college.
Yes, I have annexed the notice, my lordship. Page
Notice-
41 may be seen, my lordship.
Page 21.
41. I appeared on 25th and without examination on the same evening, it has been cancelled. So
Persons with PWD benchmark very verification report. You're not understanding what we are asking, even though we want to.
after having been selected, I appeared for verification.
To bring the updated copy of their Aadhaar, that PWD certificate must
My lordship, in extra one, my lordship,
Page.
my lordship, is, is my lordship, 29. 29, my lordship.
They were not technically required to see the case required to be heard, but why do they accept hearing? I think that you will get lucky, but no, that can- But then we can ask the learned single judge to give you an expeditious hearing.
In the
But why
meantime,
reserve seat for you? We are not getting persuaded, right? You have a you have a certificate of 40% disability by a statutory body.
yes, my lord.
But on re-verification, where is the concept of re-verification? That is what we want to know.
That is my question also, my
My
lord.
lord,
Is your question? Yes.
that I can produce, my lord, the advertisement or information bulletin of 2025, my lord.
Yes.
The relevant provision is my lord, page 39, clause 6.5, my lord.
Page 39,
Yes, my lord.
paging at the foot of the page.
The bottom of the page, my lord. Bottom, my lord. Page 39, clause 6.5, my lord. Guidelines for PWD candidate for admission purpose. Then, my lord, the relevant is 6.5C, my lord. Candidates who consider themselves eligible for this category are advised to ensure their eligibility by getting themselves examined at any government medical college, district hospital, government hospital. Such government medical college, district hospital, government hospital shall issue a disability certificate in reference to Chapter 7 of the Rights of Persons with Disability Rules 2017. Such a disability certificate is issued as per schedule to the Rights of Persons with Disabilities Act 2016. And the guidelines for the purpose of assessing the extent of specified disability in a person included under the Rights of Persons with Disabilities Act 2016, notified in the Gazette of India by Ministry of Social Justice and Empowerment, Department of Empowerment of Persons with Disabilities, Divyanganjan, on 4th January 2018, and does not confer any right on any candidate to seek admission in a medical course under PWD quota. So in terms of that certificate, they are not entitled for admission. Their aforesaid certificate shall be to ascertain whether a candidate can apply to NTA for appearing in NET 2025 under the PWD quota. So that 40% certificate has been used for qualifying to appear as a PWD under the PWD quota in the entrance, my lord. Thereafter, clause D, my lord. Thereafter, the candidates, upon selection under PWD category, shall have to produce a disability certificate issued by the Disability Assessment Board, which shall have assessed the candidate in reference to criteria prescribed under the regulations on graduate medical education 1997, as amended up to 13/5/2019. So after, my lord, selection under the quota, my lord, they have to be assessed by a duly constituted assessment board. And in this case, my lord, the petitioner has been assessed by a board, my lord. The report is there, my lord.
Right.
Because all the candidates, my lord, they have been assessed by this board, my lord. As per the provisions of this. My lord.
What is this?
His name is Shahinur Alam, my lord. His name appears at serial number 4, my lord.
I think for four. The 7th member to the metric vote. 18. Left vote. What? Right. You have to submit yourself to the assessment board.
Yes, my lordship, my contention is the repetition is that on 25th in the morning I appeared. No examination has been taken, my lordship. In the evening, that my certificate. has
That's
been
an
that-
oath against an oath. We can't rely on your statement.
My lordship.
That's a medical board's report. And that is there in the NEET regulation,
Well, from the-
NTA National Eligibility Cum Entrance, NEET UG Regulation 25. Argue out your case there. Don't, if it is found that this assessment by the board is incorrect, you will get admission or whatever. But we can't,
My lord, on 25th, my lordship. On 25th, when I
we
appeared.
have heard you.
Yes, my lord.
On the day you appeared before the board in the morning, no test taken. Ultimately, they say it is only 18%.
Yes,
This
ma'am.
is your
Ye-
statement.
Yes, my lord.
But can we deny that, I mean,
Yes, my lord.
let us see their statement,
Yes,
what
my
they
lord.
say.
I don't-
Therefore, we can't, they say when they file the affidavit before the learned single judge.
2 working days was
Can we
given.
on that count reserve one seat for you?
That is my lordship. My petition will become infructuous.
It might become infructuous, but then a prima facie case has to be shown,
Within
no?
2 days.
There is a case against you that the medical assessment board found you to be unfit for counseling. That's all.
Lordship, counter affidavit within 2 working
It's
days.
a case, Mr. Counsel.
My lord. State was directed to file counter affidavit
They
within
will.
2 working days, but here
They have
more
not.
than 2 working days has.
They
Honorable
have
Singh.
served the extra copy today only,
My
my
lord.
lord.
They are having the copies, my lordship.
Yeah. The appellant is aggrieved by the decision of the learned single judge in not reserving one seat in the medical college for the petitioner, even when it was demonstrated before him that he has a physical disability certificate issued by the statutory authority to the extent of 40%. The appeal has been filed on this limited ground as the writ petition is still pending consideration before the learned single judge. It appears that the petitioner had applied, that the appellant had applied for admission in Guwahati Medical College under the PWD quota. He was permitted to appear under the quota on the basis of the certificate of locomotor disability which he produced initially. However, under the regulation of the NEET UG 2025, any candidate upon selection under PWBD category has to undergo an assessment by the Disability Assessment Board, which only would certify whether a candidate may register or participate in common online counseling towards admission to medical courses. In case a candidate is found to be ineligible by the Disability Assessment Board in reference to the criteria prescribed under the regulations on graduate medical education 1997 as amended on 14/5/2019, he may not be registered or be permitted to participate in the common online counseling, and any online provisional allotment of the medical college would be entirely fraudulent on the part of the candidate. The appellant, the assessment of the Disability Assessment Board regarding the appellant is that he has a disability of 18% in his lower limb, thus keeping him out of the category which would be permitted under the quota for admission in medical college. Stop. Unless a person has a disability of 40 to 80%, he would not be in a position to, he would not be considered under the PWD quota for admission in a medical college. In this view of the matter, we are unable to pass any order directing the respondents to reserve one seat for the appellant in case the writ petition preferred by him succeeds. For the aforementioned reason, and finding no merit in this appeal, we dismiss the same. However, we request the learned single judge to give an expeditious hearing to the appellant by ensuring that the affidavit on behalf of the respondents is filed within time. And it would be open for the learned single judge to, under the circumstances, if it warrants, protect the interest of the appellant as far as possible. The
Highly
appeal
obliged,
stands-
my
The appeal stands disposed of.
Highly obliged.
For hearing, item 11 to 13.
Yes.
Yes, your lordship. Your lordship has asked me to file a compilation. The compilation is on the verge of getting it prepared. We only just need 3-4 days more so that we will file it positively. And so this is pertaining to PIL 6 and 2. So far as the PIL 74 is concerned, it will be better if your lordship may just detach this PIL with the rest of the PIL, because
We'll hear all of them together.
because
The
the
schools will be segregated.
because the difficulties is in PIL 2 and 6 I am appearing as a counsel, and in PIL 74 I am in person.
Doesn't matter.
Okay,
It doesn't matter to us.
it's absolutely fine.
It doesn't matter to us. We will not ask you to take out your band in the case where you are pursuing personally. Doesn't matter to us.
Yes,
Uh,
your lordship. So I will directly brief the PIL 74.
No, but be ready with the compilation, give it to us, and then we will hear
The
it.
compilation is pertaining to PIL 6 and 2.
But we will hear it all together, no?
Okay, very well.
So any date that is convenient for you, we are ready to hear, because you have flagged an issue which
Yes,
needs
yes,
immediate attention.
yes.
Now, we
In
are
fact-
at a,
in
just
fact,
a minute,
we are-
we are at a loss to understand that
Yes.
in recruitment process in the police department,
Huh.
whether they are required to create a special class of transgenders
Yes,
and not align you with the requirements similar to a male candidate
Ah.
and not even a female candidate.
yes, yes. And
So-
for that, we have, in our compilation, which will be coming up with that, we have brought up almost 12, 15 judgments and interpretations of the other
Very
High
good.
Court.
Very good. With respect to this
Yes.
creation of a special class.
Yes,
especially in
yes.
recruitment.
Recently, even we have, that is why we were a bit late in coming up with the compilation, because there was a recent judgment passed by the division bench of Kolkata High Court, saying that 1% reservation is required to be made for the transgender. So
No,
that
no,
is
these are
also,
two
yeah.
different things. Reservation is one aspect.
No,
of
no,
the
that,
matter.
yes, that is also
You have
reservation and,
primarily you have questioned the recruitment policy
yes,
where though the reservation has been made for transgender, but then the
the separate class, the separate
eligibility
classes.
criterion is similar to that of a male candidate.
Yes,
I think that's the core issue that you
Yes.
need to address,
yes, absolutely.
correct?
Yes.
So I don't think there is any judgment of Calcutta High Court on that.
No, Kolkata High Court said that
Now,
there
the
has to
difficulty
be,
here is this.
no, no,
I mean, transgenders,
Huh.
there are some who refer to them as he
Or
and
she.
some who refer to as she.
she.
Now, the difficulty would be that in this mini class, there has to be two class.
Yes,
Whether it is possible in a recruitment policy, especially for police. We'll have to see, but that judgment that you're talking about is something different.
that judgment says that 1% has to be reservation has
The
been made.
reservation,
And at the same
that
time,
is given, there is no
Huh.
difficulty.
so at the same time, that judgment also says there has to be a separate class for the T category.
Class, with reservation, class is created.
Yes,
You are going beyond that. Your prayer is that you have created a class, all right. But then give us requisite, concessions
yes.
and
yes.
don't align us with the capabilities of a
Of
male
binary genders. Yes,
of binary gender. You're right.
yes.
So that is your risk.
Yes, absolutely.
That you'll have to build up that argument. We are readily not, we cannot readily conjure up grounds in support of your argument.
So that is why that compilation will do the
All
needful.
All right, so we hear you on the next date.
Yes.
All these.
So that is pertaining to that PIL 6
Okay.
and
This would be an interesting.
at the same time PIL
topic
70
to hear.
PIL 74 is also interesting. If your lordship, I will just take only 2 minutes to elaborate the
No,
brief.
we will hear you together when we give you.
Yeah,
what
that is a that will be a detailed hearing if
let-
your lordship.
We will give you a detail here. You want in this part of the year or in January?
No, by November.
I know.
Only just 3-4 days we require. We are almost ready with our compilations.
As break for, let all the three matters be listed for final hearing on. What's- 27th of November.
27, fine. Deeply obliged.
Item 15 to 17.
May I please your lordship?
Yes,
My lord, we have filed the convenience compilation today.
today.
I have given a copy to my learned colleague. My lord, it has to be called for. And morning I could not make the mention because I was being late.
Okay, but even then, you could have said that.
Because already your lordship has gone with the daily matters. By mention, I forgot, I could not mention it in the morning.
So,
Please, he's asking for adjournment.
No. That's a different matter.
any convenient date,
Any day after.
any day?
Okay.
Any day. Yeah. Mr. Borgohain, Mr. Borgohain, learned advocate appearing in all the three matters and all the matters submits that a compilation volume has been filed today in the registry, which is not here, which has not yet been tagged with the records of this case. Let it be tagged with the record of this case, with the records of this case, on the next date. Re-notify these matters on 20th of, on another Thursday, on 20th of November. All right.
Is the highest, is it?
Item number 18.
Yes.
But the,
Yes.
the impute judgment, Lordship will find at page 145. From para 45, kindly come to page 151, Lord, para 20.
Yes, no.
Here, Lord, the
Para 20.
para 20 onwards, Lord, the person was not in service, Lord, from 2004 till 2013. And ultimately, that period has been treated as dies non. And we are aggrieved by that, Lord, the Honorable, the learned single judge, while concluding in para 25, Lord, at page 153. Finally, in para 26, Lord, accordingly, it is provided that for all other purposes other than for payment of salary and allowances, the petitioner to be treated to have been in service, and the service period of the petitioner to be taken from the date of initial appointment up to the date when his service came and would come to an end as per law, and accordingly subject to the petitioner for all such benefit that he may be entitled, as the entire period of the petitioner which was forfeited as per the
For the purposes of, this is a very generally, in a very generally couched, proposition.
Lodge.
The proposition of dies non is that, you don't get paid for that period. The service master-servant relationship continues, but then that period cannot be used to reckon your seniority.
Malad, all other benefits already that has been taken care of.
That is not in
Here,
dispute.
Malad, only the ground C, we are here, Malad, with that grievance, Malad, at page 20. That the
We are agreeing with you.
Lodge.
We are agreeing with
Lodge.
you.
So-
Use the judgments.
So that part only, Malad, we are.
Dies non period cannot be counted for seniority advantage.
Lodge.
Continuity of service is all right, but not seniority.
Not seniority.
And judgments say, they give an example, suppose A and B, these are two employees
Lodge.
who, A joined 10 days before. But some period was held to be dies non.
Malad.
B joined 10 days later, but his service was continuous. So when the gradation list was made, B was held to be senior to A.
Lodge.
So it is, the law says that it's a neutral comment.
It's a neutral
You
administrative,
remain in service.
for administrative calculation only.
It's a neutral,
Logic.
it's not an adverse marking. I don't know why the judgments say it is not an adverse marking and a neutral marking. You get paid for everything, but you can't have your seniority because for that period you are not in service.
That is where, Malad, we are agreeing.
No, that's right. Yes, Mr. Chaudhary.
My lord, what has fallen from your lordship in
No,
principle, I agree.
That's
No, no.
tentative. We
Yeah.
only
Tentative.
we voice our opinion for you to react.
No, yes. My lord, there are kindly take note of 2 dates.
No, first let us come to the principle first. We will decide your case thereafter.
Principle is very clear, my lord. Once a particular period is declared as dies non, then I'll not get the corresponding benefit for that period.
Corresponding benefit with respect to what?
With regard to everything, including computation for the purpose of pension. But question is, what is the period? That is where the catch is.
So that is not in dispute here.
That is a dispute.
Dispute here is that they say that apart from all this, you must get your seniority. That
Yes.
will not,
Ah,
because the judgment says so.
No.
And you have to show us the judgments.
yes. Milord, I'll just place two judgment, Milord.
In one of the judgments that I remember, Haryana versus OP Gupta, 1996 SCC.
Milord, I'm relying on our
The
High Court.
statement is vague, which says that it does not interrupt continuity of service. But the proposition says that it can't be reckoned for seniority.
Yes, it can be reckoned for seniority. For that period, one is not entitled to salary, one is not entitled to any increment, one is not entitled to even count for the purpose of computing pension. Yes. Diasnon means even not there, but there will be no discontinuity of service.
But what is the purpose of saying? The better expression would be that master-servant relationship continues.
Yes. Now here in this case, my lord,
The moment you say that continuity of service, that means seniority has to be given. The DS non-concept is no seniority.
yes. My lord, here in this case, that's why I said two dates are very important.
Now, what happened?
Yes. Now, if your lordship should kindly come to the impugn order, my lord, which was assailed before the learned single judge, it is at page 108. Now, may I have your lordship's kind attention to page 108, my lord?
Yes.
I'll have your lordship's kind attention somewhere in the middle, whereas from the official record, has your lordship's got it?
Yes.
Yes. Whereas from the official record, it is observed that Sri Debashish Pujari was allowed to avail earned leave from 1/7/2004 to 37/2004 by government notification dated 11/6/24. From 31/7/2004 to 28/6/26 on earned leave or any kind of leave was sanctioned in respect of the Pujari, though he submitted copies of forwarding letters from the executive engineer Dibrugarh. Fact of the matter is, my lord, his leave was from 1/7 to 37.
1/7?
To 37, 2004.
Yes.
But my lord, he went to Australia, he undertook some course, my lord, and therefore he came late. Now, what the authority did most importantly, after noticing everything, now if your lordship would kindly come to page 109 to cut short the whole thing. The first subpara at page 109. Whereas Pujari, in continuation of his earlier reply in defense dated 14/7/09, has submitted another additional reply dated 22/12/09, whereby he submissively apologized to the disciplinary authority regarding the commission, omission, availing leave, disobeying government rule, etc. Whereas department moved the file to the personnel and judicial department for their views on the matter. On going through the views offered by both the department, the disciplinary authority found that going abroad and overstaying without permission of the competent authority are violation of the established rules of the government, which attracts Rule 18 of the Fundamental Rule, unless governor is of the view of the special circumstances of the case, shall otherwise determine after 5 years continuous absence from duty elsewhere than on foreign service in India, whether with or without leave, a government servant shall be removed from service after following the procedure laid down in the Assam Services Discipline Appeal Rule. Whereas, as advised by the Personnel Department and Judicial Department, considering the pair of Sri Pujari on an humanitarian grounds, the disciplinary authority decided to conclude the disciplinary proceeding by revoking the suspension order dated 29/3/07 and 06 and treating his entire period of absence as diasnon for all purpose under FR 18, and entire service would stand forfeited as advised by Judicial Department. Whereas the view of the Assam Public Service Commission was sought for, and considering the view of the Personnel Department and Judicial Department, Secretary APSC wide endorsement dated 3/5/12 agreed to the decision of the disciplinary authority to revoke the suspension order treating the period of absence as none. Whereas Sri Pujari had submitted a court stamp paper and stated that he would never claim to the pay and allowances for his unauthorized absence period with effect from 31/7/2004 till the date of his revocation of suspension order by the government. And the suspension order issued by dated so and so was revoked and he was reinstated, treating the entire period of absence from 31/7/2004 till the date of rejoining after reinstatement in service as none for all purposes as per FR 18. Now, in view of the above stated facts, they could consider the prayer of Sri Devashish Pujari regarding seniority, past suspension allowance, etc. Accordingly, representation of the Devashish Pujari dated 21/12/12 is disposed of. My lord, my submission is twofold. Firstly, the moment I was placed under suspension on 29/3/06, the master servant relationship revived. Therefore, you can take note of the period from 37/2004 to 29/3/2006. That for that period, Dayash is absolutely okay. I cannot have any grievance against that. But the view taken by the authority that the period will be treated as Dayash from 37/2004 until this order passed by the disciplinary authority, that cannot be correct, Miller.
No,
Okay.
you joined when?
Miller, the moment I'm placed under suspension, I'm in service.
Initial period I joined in 2003.
I joined the service in 2003.
Just a minute. You just have it.
Now, please come to the suspension order, Miller.
Just a second.
Yes.
You were on leave from 1/7/2004, 37/2004, and thereafter you absented yourself in
Yes.
2006. And when were you suspended?
Place 64, Miller, 29/3/06.
Page?
64. Twenty-ninth of March 2006. Whereas Sri Devashish Pujari, assistant engineer while serving as assistant engineer PW Dibrugarh Road Rural Division, had indulged in a deliberate failure to carry out written order of the superior officers and desertion of duty, and there is prima facie evidence to proceed against him. And whereas disciplinary proceeding has been contemplated against Sri Devashish Pujari for the act of his insubordination and misconduct. Now, therefore, in exercise of the power conferred under Rule 61B of the Assam Services Discipline Appeal Rule 64, Devashish Pujari, Assistant Engineer PWD, is hereby placed under suspension with immediate effect pending royal of the departmental. So, my lord, the moment I am placed under suspension, my lord, the master servant
And
relationship
when was the
revived.
suspension revoked?
Eventually, on my lord, किमान तरीके से लिखित order दो. 1 second, Miller. 8 to order.
When was the suspension?
1 second, Miller. Miller, this is the order at 21/8/18.
Page 76.
Huh? 1 second.
76.
I'm sorry, Miller, just 1 minute. It will not be.
No, that's right.
What of them? Google us.
You did.
Hmm?
Revoke the order of suspension.
At the page, my lord. Iman. I think page 76, my lord. With reference to the subject cited above, on 30th of May 2012. With reference to the subject cited above, I am directed to say that the department is now considering to dispose of the DP drawn up against you by order dated 19/3/09.
You're reading page 76.
Yes, my lord. 30th of May 2012. হয় না? এটা order হয়ে যাবে।
Yes.
With reference to the subject cited above, I am directed to say the department is now considering to dispose of the DP drawn up against you by the order dated 19/3/09 and to revoke the order of suspension. But it is observed that prolonged silence have been maintained by you in this regard. As such, you were requested to response into the matter with a medical fitness certificate certified by the Joint Director
This
of
is
Health.
no revocation of suspension. This is no revocation of suspension.
Lordship, may kindly come to page 141.
1 second.
141.
Later, let him.
Lot.
141.
Yes, yes.
Oh, yes, yes. No, ঠিক আছে, he's right. Page 141, yes, Miller, I'm sorry. Miller.
Difficulty is that before that you come to page 75. That distinction you should not be asking to be made.
Page 75, Miller,
Yes,
my undertaking.
yes.
As desired, I hereby declare that I shall not claim any PON allowances for the period from July, that is till date,
That
and I am
is the date
reinstated in
reinstated
service on revocation of the order of suspension
dated
dated so and so.
29/3/2006.
Hmm.
So revocation of suspension is 29/3/2006.
Yes.
So this entire period of suspension also, you say that you shall not claim anything. And that's the reason why departmental proceeding was, what is that called?
But even then, this is 2010, Miller.
No, that's all right. But then you are seeking, you say that DS known is only for the period 17/2004 to 37/2004.
We agree.
But then you have yourself admitted, and for that reason, for your concession, for your, agreeing to it, departmental proceeding was not continued. Otherwise, you would have been dismissed. Overstay is a good ground for dismissal, Mr. Chaudhary.
Correct.
You know
Miller.
several cases.
Assuming what is
So
followed.
therefore, unless you pray that this waiver, I may have said this, I will not abide by it. That's something different.
But I was only trying to visualize it.
One page, 140.
But end of the day, my lord, having taken note of humanitarian consideration, I know it's not an open and shut case, but only question is, my lord, is the view of the learned single judge so bad or so unreasonable?
No, it is very unreasonable. They don't, sorry to say, but it is unreasonable. It goes beyond the principle of DS non.
No. We were suspension period of 2006 and
And please come to page 141 now. Mr. Chaudhary, come to page 141. And good, you are in service. Everything is all right. We are not in agreement with the order passed by the London Single Judge.
Page 141, my lord.
Yes. Now come to
After
the
thorough
first
examination of
paragraph.
last paragraph,
Then the first paragraph of findings.
show cause of finding.
Hmm.
After thorough examination of all relevant documents, views relating to the case of Devashish Pujari, Sri Pujari is responsible for his unauthorized absence and foreign trip. In response to the show cause notice as stated above, Pujari submissively apologized to the disciplinary authority, and also an affidavit has been submitted by him where he declared that he shall not claim any pay and allowances from so-and-so till the date of his reinstatement in service. Department moved the personnel and judicial department for their views in the matter. Personnel department opined to consider the case of the Pujari under provisions of so and so, however, judicial department opined that the entire period of absence may be treated as dies non for all purpose under FR 18. Further, apart from taking disciplinary action, the entire past service stands forfeited. Moreover, as per rule so and so, department moved to the Assam Public Service Commission for the views in the matter of conclusion of DP in respect of Sri Pujari as advised by the personnel department. After careful consideration of all aspects, it is
Your
ordered to
suspension
conclude.
period also will go in that DS note.
No, my lord, all that I was trying to.
Technically, if you had not said that, we would have considered, right? You can't be suspended unless you're in service. Reinstatement is suspension revoked.
Revoke.
But suspension, but you were in contemplation or you were not to be found. You could have been served, a suspension order could have been issued against you even though you were in Australia.
Yes,
Correct?
no, my lord, I am not on that. When there is a suspension order, the moment, but for the suspension order, I wouldn't have had a case. Let me be very clear about it, my lord. It is only because of the suspension order
But how about
which revived the
how about
master
your-
servant relationship.
how about your undertaking
No, no,
and
the
decision?
undertaking is up to 2010,
No, no.
Yes.
Only for the period.
only period.
No,
Please have a look, my lord.
Till the date I am reinstated in service on revocation of the order of suspension.
Yes, that is on 2010,
75, page 75.
page 75, my lord. Yeah.
As desired, it was desired by them,
Mila, kindly see, this starts with as desired.
it was desired by them.
You you are an officer. You have been trained. You have done your research in Australia as desired. Nobody could have forced you.
No, Mila, till that has to be construed as 18th of June 2010, Mila.
No. Where is the order of revocation of suspension?
No, Mila, it will be too harsh to, I mean, give effect to
When
this.
was it recovered? When were you? I mean, this
Page 143.
no, this goes only in 2018.
No, page 143 is the order, Mila. 1/10/2012.
First of October 2000, the governor of Assam is pleased to revoke the suspension. First of October 2012. Yes, same thing.
The governor of Assam is pleased to revoke the suspension order issued by these departments dated so and so in respect of Sri Devashish Pujari, so and so.
Till the date of rejoining after reinstatement.
Milord, there is one catch, Milord. If my joining is now to be treated as 2013 as they are contemplating, then Milord, I joined in 2003. My period may not be computed for the purpose of pension, the period of dies non. But if it is 2013, Milord, then I lose the benefit of old pension scheme also. Because I joined in 2003, before 2005, whosoever joined, they are entitled to pension.
No. Your joining of 2003, you joined only in 2003.
Yes.
So how is it going to affect your pension? Old or new?
No, my lord, because now they are going to treat my appointment as if it is new appointment from 2013. Yeah, that lordships will clarify.
We will clarify.
Yes.
The period in DS loan begins from 37/2004. And it ends with.
Please come to the impugn order, my lord.
No, and it ends with 1st of October 2012.
After the impugn order.
That's why at page 153, para 26, my lord, that's what has been said by the learned single judge.
Order will take it.
This is the operative portion of the single judge's order. Accordingly, it is provided that for all other purposes other than for payment of salary and allowances, the petitioner to be treated to have been in service and service period of the petitioner be taken from the date of initial appointment up to the date when his service came and would come to an end as per law and accordingly subject to the petitioner to all such benefits that he may be entitled to.
No. This order, otherwise, I think you should have challenged this order.
No, therefore the petitioner would not be considered.
I think you should have challenged
No,
this
the
order.
last sentence. Therefore,
to be
the
a new entrant in
petitioner
service
would not
after
be
the
construed to be a new entrant in service after the impugned order dated 21/8/18.
That is not the intention, that is not the import of the order which you challenge.
That is why I came back clarification.
Milord,
With the date of revocation, tell you.
2013, 86, page 86.
I have two submissions.
We are allowing your case, no?
That's true. But the two information I must give, no? They have also preferred a reappeal.
18.
And
They have also preferred.
Sir,
reappeal, they have also preferred reappeal against this judgment. That has been dismissed.
now if your lordship would kindly come to page 85, Milord.
Why did you prefer an appeal against this?
For pay and allowances.
No, Milord, I didn't prefer an,
Yes,
I prefer
appeal was preferred.
appeal.
It was dismissed, Lord. This is the order.
appeal was dismissed.
Mr. Chaudhary, first time I am finding that you are slightly tentative on facts. First time over a period of 3 months.
My lord, while dismissing the appeal,
I'll
If
tell
if
you
your
one
lordship would kindly come
I'll
to,
tell you one thing. Take your briefings properly tonight. Come
Okay.
tomorrow and then ask us for only one line.
yes,
We propose to give you the DS non period from 34/2003. What is that date?
7,
I
37, 2004.
till 1st of October 2012. That's all. Not 18.
Milord, my humble submission would
And
be
your
my
mark is-
date of undertaking, Milord.
No,
85.
no, because date of
86
undertaking
is
also is a date where you say that you reinstate. Then that's because they would have otherwise continued. Because it doesn't make much of a difference, but otherwise also, Mr. Chaudhary, you can't blow hot.
No,
and
Milord,
cold.
there is one more glitch, Milord. If your lordship would kindly come to page 85.
One second,
Yes,
Page
yes.
45.
Hmm.
Where was it?
This is principal reason why we had to approach your lordships, Milord. Page 85.
Yes, sir.
The provisional seniority list of assistant engineer was published. Then if your lordship would kindly come to page 86, serial number 113, Milord. Debasis Pujari, kindly see, date of birth is 16/2/68, date of joining 24/6/13.
एक second. Date of revocation is 29. Please to revoke the suspension order issued by this dated suspension order was passed on 29/3/2000. And page 143.
All that they wanted to do was,
No. Sir, look at your
Yes.
undertaking, even if it is as desired by the authority.
Huh.
I shall not claim pay and allowances for the period from 31/7/2004 till the date I am reinstated in service on revocation of the order of suspension dated. The suspension order date 29/3/2006, don't confuse it with the revocation date.
yes.
So therefore you say that till the time, this is the date when you give your undertaking, and therefore the government takes a decision.
But they took 2 years, Milord.
I had given a letter from 2009.
And why was your appeal dismissed? And what did you file an appeal for?
My appeal was only because during the suspension period, I was not given any allowances, nothing was given.
Actually, Milord, I think the
What
appeal,
is the name of your briefing counsel?
Mr. Sharma.
Mr. Sharma, you should have told your senior that this order was challenged by him also, by you also,
Yes.
and it was dismissed. Challenged on what ground?
My lord, may I just submit here?
Yes, what?
My lord, I was the arguing counsel in the Learned Singh.
You may have been the arguing
Yes,
counsel,
sir.
but
Yes, my lord, we had challenged. What has happened in this case is, my lord, during my suspension period from 2006 till I was reinstated, I was not given a single penny of the substantial allowances. Nothing was given. In 2009, I
that's
wrote a
right. When finally it is converted into
perfect seniority
Mr.
list.
Chaudhary, you tell him the law.
No, my
Question is that, see, you should have remained under suspension. You should not have agreed for this. And you should have allowed the departmental proceeding to be continued.
my lord, the DS.
Then you could have claimed that during that suspension period, you are not given subsistence allowance. This period, as a matter of compassion shown to you, was converted into TS non. Therefore, what you did not get, you did not get. Finished.
Anyway, Milord, lordship will give me some time. Let me also go through it. Lordship will have I'm sorry, I have taken some time of your
All
lot.
right. Many a times you would find this court not ready. I mean, that is
no.
understandable. That is understandable. Therefore, I said in 3 months, first time I'm finding that.
My only prayer would be, my lord, to persuade your lordships to take a view
You will not.
that diastron
Provided you read the file today, take instructions, you will come tomorrow and say that whatever order your lordships are about to pass, please pass. I
instead,
don't think you'll ask for anything more.
instead of tomorrow, my lord, could it be Monday, my lord?
Any day.
Yes, Monday.
The reason is this. Monday I am not here.
Okay.
That week I am not here.
Any date convenient, my lord.
It's a short matter. Now there are two things. Suspension date, there was substance in your argument. Substance in your argument that the moment you are put under suspension, whether we agree to
Revives.
it revives. Therefore, it would be deemed and you would be entitled for your subsistence allowance. But nothing was paid to you and you must have, interacted with the government authorities, the superior authorities. They would have said that please seek apology and ask for the entire period to be treated as DS non, nothing more, no departmental proceeding. So no departmental proceeding, everything was done. You were not paid your subsistence allowance, but then you have to forget it because it is DS non. And this undertaking you have given. Undertaking, of course, IT, Income Tax Department versus Basheshwar Nath.
No waiver of fundamental
No
right.
waiver of fundamental rights. We remember that is one case which all of us
64.
all of us have studied in our student days. No waiver. But here, in case of service jurisprudence, this is the order. You have to follow it. We would treat it as DS non from 37/2004 till 1st of October 2012. 8 years.
There was no
Make necessary modification in the single judge's order.
All right, let me also go through it, my lord. Lordship will kindly have.
And again, our undertaking that in that case, when we are doing it and you are agreeable to it, we will not look at the reason why your writ appeal was dismissed. If your writ appeal is dismissed, then this order stands.
I followed.
In fact, my lord, appeal was dismissed.
After some arguments, Mr. Ken Chaudhary, learned senior advocate, seeks some time to take further instructions and address this court. Re-notify on plot
11th or 12th.
11th or 12th. 11th or 12th of November.
12 November.
In fact, the judgment of the learned single judge is highly flawed. It says that you must get everything. What is the meaning of DS non then? That order otherwise also goes.
The principle is well
And we-
settled.
and
What
we
would
will-
be the effect of diastron, Miller? There are umpteen number of cases.
Umpteen number of cases, but the one that I remember, there is only confusion when there is a vague statement in one of the judgments that there is a service continuity. This was the case where seniority was trying to be reckoned from that
In
day.
fact, there was one point of time, there was a feeling whether it will result in cessation of master-servant relationship. Eventually, Supreme Court said no. He will be deprived of the benefits.
They use the word neutral marking.
Yes,
It is a neutral mark.
yes.
All right, no?
Item 19.
Oh, yes, Mr. Mishra.
My lord, we are challenging, my lord, the constitutional validity
Yes.
of Nagaland Land Resource Development Department Service Rule 2008.
Yes.
My lord, the case has a checkered history. It has a second round. If your lordship permit me, I just give the brief facts.
Yes.
My lord, Government of India undertook Westland Development Program to develop, my lord, 49.79 million hectares of non-forest land. By adopting a multi-pronged approach and named it as Integrated Westland Development Program. it requires support of multidisciplinary professionals. So professionals from all fields who are required they may join this, my lord. Now, later on, my lord, the state of Nagaland also adopted it, and then state of Nagaland created
Mr. Mishra, how long will you take this?
I'll take some time. my lord.
That's not a question which should be asked to a counsel who has just begun his arguments.
My lord, I'll take some time.
That's not a question, but then you're outside Guwahati.
No, I'm in Guwahati, my lord. I was not that well, so I decided to do it.
And Mr. Balgopal, you will be, of course, contesting. You will be defending the legislation.
Please, my lord.
All right. So you'll take some time. So we will fix one date
Very well.
when the matter would be heard finally.
Right.
My lord, if your lordship can hold the first item, as he give me indulgence. my lord.
I didn't hear you, Mr. Mishra.
My lord, if your lordship can take up as a first item of hearing on whichever date your lordship takes it up.
Yes, we will keep it as first case on a particular day.
Your
Now,
lordship may, I'm here only, your lordship may.
all right. So you want this hearing this year only, or could it go to
Yes,
January?
If it can be, my lord, this year, subject to what.
All right. So we give you a day in the December. Where is the calendar of December? December.
Your lordship may make a short for me. I am respondent number 6. The order has been passed against me from 2003.
All right.
My lord.
No.
9th of December.
See, we don't want to give a piecemeal hearing today. If it is not concluded today, then it spills over for tomorrow.
Oh.
Then all the efforts made by Mr. Mishra and Mr. Balgopal would go waste. You know, human memory is too short. No?
Thursday, no?
And then, so it has to be a one day.
Milord, 4th of December, Milord.
4th of December. First week of December. No, I'm not there. Second week of December. No.
Then 9th will be.
That's 9th of December, Mr. Mishra and Mr. Balgopal.
ठीक है, 9th.
9th of December. Just a minute. If there are many matters on 9th, then we'll adjourn the matter and we'll hear it. Only 5 matters. Don't keep any other matter. This is a priority.
9th of December.
9th of December. Let this matter come up for consideration on. Let this matter come up for final hearing and disposal. Final hearing on 9th of December. And don't put many matters. It will be listed at serial number 1. We'll start hearing from 10:30.
Very
well.
Yes.
Item 22.
May it please your lordship, in this matter, lordship, Mr. N. Khatuniar appears, lordship. Today, due to some medical appointment, lordship, he had to leave court, lordship.
Who appears in this matter?
N. Khatuniar, lordship.
Okay,
NJ
he was
Khatuniar.
here.
He was here, lordship. He had to leave court, lordship.
Nothing serious has happened.
No, lordship. No, nothing serious, lordship.
On account of as prayed for on behalf of the respondent on the ground of non-availability of Mr. Khatuniar. The matter is that yes, you have no problems.
My lord.
The matter is adjourned to 9th के बाद कभी 10th of December, 11th of December. Deeply obliged.
Obliged, my lord.
Item 23 to 25.
इसका बस हो जाता है Advocate General. Yes, Mr. Chaudhary, Qazis.
Yes, Qazi, my lord.
Where is the Advocate General? Mr. Sharma, Mr.
My lord.
Mr. Sharma, you will be addressing us.
My lord, if otherwise not inconvenient, may I request to pick up any other day, my lord? My lord, Advocate General instructed me to.
That's right. We have also requested the Advocate General.
Yes, my lord, last time, your lordship.
Muslim 1930, repeal of 1935 Act.
Repeal and 24 Act has come in
2024 Act.
act, my lord.
Concise argument करेंगे आप, Mr. Chaudhary.
Yeah.
Very concise argument.
On a basic question, my lord, this act was known as Assam Muslim Compulsory Marriage Act. First name itself suggests, my lord.
We will, iska kaun sa date?
Yes.
Which date, Mr. Advocate General, would be here?
After 9th,
Huh?
after 9th of November.
November.
Last time also I expressed my urgency, my lord.
Can it go in January?
Madam?
Can it go in January?
2 months. My lord, last time also your lordship was pleased to fix today, my lord. I made a prior to 2 days, my lord.
Okay. All right, November, बोलो कोई date website पर नाम here कितने दिन रखा? Hearing का date किसी Friday, Thursday? 11? हाँ, 11th November. 11th November.
11 number published.
11 November.
Like these matters we listed.
Is it okay, sir?
on 11th
Only subject to their, whether AG will available or not, my lord.
11th of November. If Mr. AG is not there, Mr.
My lord, that
My lord.
was clear. That's one.
Okay, the Lord. All right. Otherwise, we could have asked Mr. Chaudhary to address us, but no, well, see, unless both sides are there, arguments, you tend to forget. It's always better to decide on the day that you hear.
Yes, that's why I think, my lord. Well, I think 1 hour will do, my lord, in this case.
Oh.
1 hour will do. Second half, your lordship.
1 hour of a lawyer means into multiplied by 3.